It's there in the list. 27. What is the number, case number? 96. Wherein cause list indicates that there is retirement.
I have filed wakalat.
You filed.
Yes, I have filed wakalat.
When did you file?
Yes, ma'am.
When did you file the memo?
I did not file the memo. They have filed the memo and I have filed the wakalat.
The registry, pass over,
Yes.
ask them to,
Serial number 28,
yes,
28, Rudrappa.
Appearing per petitioner, my lord, process paid, my lord.
it is submitted that the needful is done, discharge the service of notice, delete from the caption.
Serial
Dismissal,
number 29, Shivayogi Math.
yes. Same, the writ petition of the RPFC of 2021 came up on 18/7. No notice to the respondent, dismissed.
Serial number 30. Serial number 30,
So many of your matters are listed, you have not even appeared before the court. A week's time default order.
serial
Court
number
can't be
31,
taken very casually.
31, DN Mamta. Priyanka.
Same 21,
Serial number 32, divorce. 33. Serial number 33, Raju CN.
so 21 RPFC, last occasion and same, yes. Yes,
Serial number 34,
same 21 RPFC, last date of hearing and dismissed.
serial number 35,
I'm
Hemchitra.
filing memo for withdrawal.
Take that.
Petitioner is died, my lord.
You submitted that a memo is filed stating that the petitioner is no more.
Serial number 30,
Petitioner died.
Petitioner died.
Petitioner died. The same is dismissed as abated.
serial number 36,
Memo is filed stating that the petitioner is no more. Yes. 30?
36,
Same. It's a RPFC of 2022. Last occasion or representation today for dismissal. Yes, dismissed.
37, Manjula Devi Kamajolli.
1 week. A week's time default order.
Serial number 38,
Wherever they're taking that, delete from caption for this.
serial number 38, Vishnu
Yes.
TM.
Yes, sorry. Same order.
Serial number 39,
Your Honor, 6 for adjournment. It's for office objections. 6 for adjournment.
PF has to be paid.
We'll pay it today, Your Lordship.
You already paid.
No, we are paying it
It
today.
is submitted that during the course of the day. Same default order. It's next, delete from caption.
Much.
Yes.
40, Rosa.
For the petitioner,
Madam.
Your Honor, the petitioner was directed to pay 2,50,000 as deposit, and he has not intimated regarding the deposit. And we have tried to communicate with the petitioner. There has no communication. The petition may be dismissed here.
How can it be dismissed like that?
There has been no communication. We are trying to, he's not interested to prosecute the matter.
Record that. That's your submission. File a retirement memo if you are not. How can you say dismiss the petition? If you do not want to represent them, file a retirement memo. You have to send him some communication,
But we do not know the address. There has no
whatever address
communication.
that is available.
But we have no address. We are not able, the phone number is not available. The address is not available, Your Honor.
The counsel for the petition submits that. They try to contact the petitioner. The petitioner whereabouts are not known. They are not able to contact the petitioner. Hence, it is submitted that the RPSC may be dismissed. Registry is directed to issue notice to the party. Yes, and the process shall be paid within a week default order. Yes, next.
Till number 41.
No, I have to the petition.
David.
I have paid the process fee.
It is submitted that the needful is done, list after service of notice.
Cell number 42. Ravi Shankar S.
Yes, dismissed.
Cell number 43.
Same order.
Cell number 44.
A week's time default order.
Cell number 45.
So the petitioner, the matter has been settled and the parties are staying together. Kindly allow me to withdraw the,
It is submitted that the parties have, counsel the petitioner, the parties have amicably settled the matter and nothing survives for consideration in this petition. Accordingly dismissed as in practice.
Cell number 46.
Forty, 47, my lord. My lord, 47, I have already taken steps, paid the process.
47, process is paid, delete from the caption dismissal. List after
Great.
service. 48,
We have paid.
yes, process is paid, delete. Default, list after service of notice. Yes, 49.
49.
My lord, 43 also paid the process.
Huh?
43 also paid the process. 43 serial number.
What were you, where were you when 43 is called? 43, what happened?
DN.
Dismissed. 43 to submitted to the process, needful is done, list after service of notice. Yes.
Much of it.
Cell number 49. T. Sheshgiri Rao.
Appearing for petitioner, Your Lordship. Your Lordship, in this matter, we have filed a recall application, so kindly it may be allowed, Your Lordship.
Give that. What are those IAs? Where are the IAs?
IA 1 of 23 and IA 1 2 of
IA 1 no? Is for what?
for reading.
For the order dated 3/3/2023, passed with the registrar protocol, raised with the registry. RPFC of 2022, no notice. At the time of compliance of office objections itself, it will be dismissed. And what is, no, they must have already filed the execution petition. They must have already, the order must have worked out by this time. Have you any instructions? Whether execution petition is filed, what happened to the execution petition? Because there is no stay from this court. Please get instructions.
Yes,
And
Your
counsel for the petition shall get instructions with regard to about the execution. List this matter day after when? Day after tomorrow?
Yes, Your Lordship.
Day after tomorrow.
Cell number 51
What happened to 50?
or 50. Cell number 50.
Yes,
50.
dismiss,
Rajana.
dismiss.
Cell number 51. 51.
Same order.
Vishwanath. 52.
For a week's time may be granted, my lord. I will collect the.
Why you were not there yesterday when the matter called?
I'm not unwell, my lord, that day.
Hmm?
Not unwell, my lord.
A week's time default order.
That will.
Yes,
Cell number 53. Abu Bakr Shafiq.
then I'll impose costs in this. Having so many matters in the
Already
list, you
taken
don't
one.
appear.
One time already taken, kindly grant one. second time.
A week's time is granted on cost of rupees 1,000 to be paid to the Advocates Association. You have so many matters in the list. In not even one matter you appear before the court. What is it? A week's default order. A week's no cause.
Cell number 54. Triti SP.
Appearing for the petitioner, ma'am. Kindly withdraw the.
You want to withdraw? Take that. A memo is filed stating that the matter is settled before the family court on 31/3/2024, and as a petitioner do not want to pursue the petition, accordingly dismissed as withdrawn. Next,
Cell number 55 disposed. 56. Anand RB.
Yes, paid.
wait, process is it's submitted that the needful is done. This is matter after service of notice.
Cell number 57. Girish NR.
Dismissed.
Cell number 58.
Hmm?
58.
A week's time default order.
Cell number 59.
Process paid.
Yes, ma'am.
Yes, process paid.
Cell
Yes.
number 61. 60. Cell number PM.
We have filed a memo for it.
Let's see. Now, how can you file a memo like this? Before filing a memo of retirement, you have to issue notice. You have to file the acknowledgement before the court. Nothing. It's not, that's not the way. That's not the way. How you have communicated, that you have to tell the court. The land counsel, the petition submits that. That they have filed the memo of retirement. This court has perused the said memo. No details pertaining to information to the client. The petitioner, the counsel for the petitioner shall file a proper memo of retirement. List this matter on 30th. Delete from the caption for dismissal.
That's okay.
Cell number 61. 61. Indra Priya.
Yes, dismissed.
My lord, for the petitioner in this case, my lord.
Which case?
My lord, 61, my lord. I seek a week's time, my lord. For
Week's time
bringing the
before the order.
delay, my lord.
Yes, 62.
Cell number 62.
Petitioner. Sorry for apology, madam. Medical emergency is there on Friday.
Yes.
1 week time, madam.
A week's time default order.
Please.
Yes,
63. Cell number 63.
No, it's
Madhusudan Rao.
trying to determine the correct address, my lord. It's 2 weeks time to take process. Correct address ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. We are trying to determine it of
A
respondent.
week's time, whatever you should have done by this time. A week's time default order.
Cell
Much
number
obliged.
64. Prasad BS. 64.
Dismissed.
Cell number 65.
For appellant, some correct address furnished.
A week's time default order.
Cell number 66.
For the petitioner, my lord.
And
Process
Prasad.
is paid, my lord.
Needful is done.
Cell number 67.
For the petitioner, my lord, it's a week's time.
A week's time default order.
Cell number 68.
All these matters, wherever represented, delete. Yes,
For petitioner, my lords. We have paid, my lords.
yes, process is paid. It's submitted, the needful is done. Yes, list after service.
Cell number 69.
Appear for petition, my lord, a week's time maybe.
Sunresh.
Week's time default order.
Cell number 70.
PF paid already, it's being paid there. PF already sent to,
It is submitted in the course of the day.
and then
The
the
process
address
will be
also is
paid.
furnished, my lord, and then
Huh?
proof for having deposited the amount, maintenance amount,
The,
up to date, my lord, it,
it is submitted that they're paying the process in the course of the day. If the process is not
No.
paid, the petition shall stand dismissed without, file it in the section.
It-
The,
proof for having deposited, proof for having deposited maintenance amount.
that's what pay before the,
Yes, yes, maybe not.
now that it is coming only for the process.
And non-filing.
That is all.
Yes,
Cell number
yes.
71.
same default order if it is not paid. Yes, 71.
71. Anant Narayan BN,
Dismissed.
Sale number 72.
Appeal for appellant in this case, my lordships. The order of this honorable court is complied, my lordships, and I had taken steps, my lordships. It has returned as addressee left without instruction. And I take fresh steps, my lordships. I pay the process.
That's what is coming up for taking the fresh steps.
Yes, my
The
lordships.
a week's time default order.
Sale number 73.
Dismissed.
Sale number 74.
Dismissed.
Sale number 75.
Dismissed.
Sale number 76. 76.
Dismissed.
Sale number 77.
Appearing for the 1 week time maybe.
Week's time default order.
Sale number 78. Abu Bakr Shafi.
Please, this advocate Abu Bakr Shafi, how many matters are there? Please count in today's list. And for each matter, 1,000. 78. Please count. No, this is not the way. Where is your
The last
senior?
matter.
Where is your senior? Ask him to come. What is
And
this?
1 week time.
7
We
matters,
will
8
take-
matters are listed in the list.
In 3 days.
And you
we-
people don't even bother to come to the court. I can understand. At least one matter. No.
I will-
Ask your senior to
I
come.
will inform, madam. He is in court number 14.
A week's time default order. Oh, very,
Obliged.
Sale number 79. Chandrasekhar GM.
Not 1 week time maybe. Right?
week's time default order.
Sale number 80.
No, 1 week for what?
For compliance of office objections. In 79. 79.1, no objections.
Then you take notice.
Please, ma'am. I will undertake.
In 79, Mr. Santosh or Nelkundi is directed to take notice on behalf of the respondent, and the counsel for the petitioner shall serve a copy of the petition on the counsel. Office objections shall be complied with within a week or else default order. Yes, next.
Sale number
80.
80. Girish B. Baldare. Sagar V. Shastri.
For petitioner, my lord. My lord, kindly 1 week time may be granted to file an acknowledgement, my lord. The maintenance.
What memo? No, this you're giving somebody else's memo.
RPFC code.
Yes, what is this memo? Why is it given? What is this? This is a wakalat.
ಯಾರಿಗೆ ಯಾಕೆ ಇಸ್ಕೊಂಡು ಕೊಡೋದು ಬ್ರಾಂಚ್ ಅವರಾ
For whom? For the second respondent. For the second respondent, notice is already served. Print the name of Nirmala. What is the initial?
Shastri and Shastri.
No, advocate's name is there. Advocate's no. Been, what is it? Shastri? No, Wakalat is already filed on behalf of the respondent. List is matter. This is directed to print the name of the advocate for the respondent number 2. List the matter on 19th for preliminary hearing.
Interim order may be.
Interim order, all are granted is extended till then. Next.
Much.
Sale number 81.
Yes, dismissed.
Sale number 82.
Appearing for the petitioner. 1 week time.
A week's time default order. Yes,
Sale number 83.
dismissed.
Sale number 84.
Dismissed.
Sale number 85.
Here for petitioner, like, course of the day,
Course of the day default order.
acknowledgement ke 1 week time ಬೇಕು. Lower court ಅಲ್ಲಿ 50,000 ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ. 1 week time ಅದು.
For the non-filing of alternate.
Yes, a week's time. Yes, next.
Sale number 86.
My lord, needful is done. My lord. Needful is done, my lord.
In 86?
Yes, my lord. In 86, needful is done.
Is done. Yes, list after service of notice.
87. Kemparaju.
That's petitioner settling the matter, my lord. Petitioner respond. Kindly have it after 2 weeks.
Whatever you want to do. Process has to be paid.
A week's time, my lord, so I'll take the fee.
A week's time default order.
Sale number 81. 88,
88.
Harish Bandari.
88.
Steps has been taken on 18/7.
It has been, it's
Yeah, but last
submitted
week.
that already the needful is done, list after service of notice.
Number 89,
Yes, 89.
My lords, I appear for a petitioner, my lords. The address that has been furnished, my lords, is of a rental address of the respondent wife. My lords, if I may be given permission to serve on the trial court advocate because it seems to be incorrect.
What is pending in the trial court?
Trial court, my lords, this is it's not pending, my lords, but if we may be.
Then why will he take notice? when
This
he
is the
not
only
representing?
address, the only address. my
Execution is filed,
lords. Execution has not been filed, my lords. It's been stayed, my lords.
same, a week's time, default.
Please,
order.
my lords.
Yes, next.
cell number 90, Victor Manoharan,
Dismissed,
cell number 91,
dismissed.
cell number 92,
Appear for petitioner.
CNC.
Already respondent file wakalat.
Where is the wakalat?
Already case
Look
statement.
at it,
92 CN.
wakalat is filed.
Respondent already ಹಾಕಿ list ಅಲ್ಲಿ ಬಂದಿದೆ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
No, listed is not there.
It's not
Okay. PF paid already paid PF.
Process is, list, the needful is done, list after service of notice. Next, 93.
93, Harish Bandari,
Steps.
Already
process-
taken.
Steps are already
First,
taken.
one submission.
This is matter of service.
Serial number 88 and 93. I may be permitted to take the notice through the council who represents the court below also, your lordship.
Execution petition. Execution petition.
Not execution, lordship.
No, because RPF, if there is
RPF
nothing
should-
pending, how will the advocate, why should he take notice? He should hold wakalat for taking notice.
Because what happens, your lordship, some of these addresses, they kept on
That is
changing.
true. If something is pending, we can, otherwise we cannot. Yes, next 94.
cell number 94,
Needful has been done.
Raghavendra,
It's submitted, the needful is done, list after service. Next,
cell number 95,
yes,
Pratap,
dismissed, dismissed.
cell number 96,
Process paid, my lordship, but
Needful
notice
is
may be,
done.
my one submission, notice may be issued to the advocate who represented the respondent.
That's
before
not
trial.
possible, yes.
cell number
Please.
97, KS Ganesha,
Yes, dismissed,
cell number 98,
For the petitioner, process taken, my lords.
yes.
Interim
The
order
steps
will
are
be
taken.
Interim order
Needful
will
is done, list after service of notice.
interim order
Yes.
will be extended.
Interim order, in all these matters, wherever represented, interim order is there, look at it, if it is there, extend in all the matters. Where there is no representation, no, not to extend. Yes, 99.
Please, my lord.
99, I am preparing for the petitioner. Needful is done, my lord.
Needful is-
Permit me to take summons and summons is also ordered to respondent.
The needful is done, list after service of notice.
cell number
Achoo.
100, Syed Nasiruddin,
Yes, 100.
Appearing for the petitioner.
I'm the respondent. I'm the respondent.
What respondent? You have to have an advocate or you should appear as a party in
I haven't
person?
been given the notice. They have given my old address and old phone number so that I don't get the notice. I haven't got.
No, you want to engage the advocate?
Yes, I want to engage.
Look, the counsel, the respondent is present before the court and seeks time for engaging the counsel. List this matter on 5th of August.
Okay.
On 5th of August. List this matter on 5th of August for preliminary hearing.
cell number 101, Gadi Lingappa,
For the petitioner, my lords, we have paid the PF, my lords, only PF cover was not furnished. Saturday, we have given in to the office directly, my lords.
It is submitted that the needful is done, list after service of notice.
Interim
Next.
order may be extended, my lords.
Interim order all granted is extended.
And we have already paid, my lords, as per the direction we have paid in the lower court, my lords. We'll file it with memo in the account.
What is that?
We have been directed to make the payment of 5,000 per month, my lords.
We are not on that point now. We are only on process.
Please, my lords.
Yes.
102, Mahendra
Needful
Ji,
is done, my lords. PF is already paid. Please.
103,
Petitioner. Cases run.
Yes,
My interim order action, madam.
it will be done.
Pay agide, madam. Process pay agide, madam.
It will be extended in all the matters where represented. Yes.
104,
Lords, in chair apologizes, my lords, on the last date of hearing as unrepresented, my lords. A week's time may be granted.
Weeks time before.
Grateful.
Cell number 105.
Needful is done, my lord.
Yes.
Cell number 106.
Hearing for the petitioners,
Shetty.
a week's time may be
Week's
granted.
time default order.
Please,
Cell number 107. Rajgopal Naidu.
What is this service of no?
Service of notice.
107.
awaited.
No representation on the last occasion. In this is a different matter. WP 16025, and there is no representation on behalf of both the party, on behalf of the petitioner. As the matter was directed to be listed today. Today also there is no representation. Accordingly dismissed. Next.
Cell number 108. Shweta Bisni.
Yes.
Bucket Bisni.
It's a petition of 2024. So far process is not fair. Even for the first time, the issuance of notice on the respondent number 1. Accordingly dismissed for non-prosecution. Yes.
109 disposed. 110. 110 also disposed. 111.
Needful done, my lord.
111.
It is submitted that the needful is done. List of the service of notice.
Cell number
Next.
112.
Here for petitioner.
Acha.
Week for time.
Huh?
1 week time.
A week's time default order.
Cell number 113.
Yes, already been paid, my lord.
Submitted that the needful is done.
It's on 18/7 itself I
List of the
paid.
service of notice. Yes.
Cell number
That's all.
for orders. Cell number
Interim order
114.
waste.
KS Srinivas for orders.
No representation. List this matter for dismissal tomorrow.
Cell number 115.
Correct address is not known to the petitioner. There are 3 petitions which are pending before the family court Shumaga. One matter, Miller, C-Miss 5 of 2025, which is posted today before the family court. MC number 22 of
The
25 is
petitioner is permitted to take out hand summons on the counsel appearing with the respondent in,
Shumaga family court.
what is the number? Give that
C-Miss
number.
5 of 25.
Write on a paper and
Please,
give
please.
in so and so, and shall file a memo to that effect by 7th of August.
Please.
Or else the petition shall stand dismissed without further reference to the court.
Interim order may kindly be extended.
Interim order earlier granted is extended.
116.
Yes,
TK Raj.
no representation. Less a matter for dismissal tomorrow.
Cell number 117.
Give that.
For the respondent, my lords. They have challenged the order granting maintenance under section 24 of Hindu Marriage Act, my lords.
The office has raised an objection with regard to maintainability on no, but maintainability is held that a writ petition is maintainable by order dated 27/12/2022. Then why the same thing is, why it is again in the, why in the maintainability of writ petition? You find it in the cause list when that is already overruled by the court. This court on 27/11/2022 itself has passed an order that the writ petition is maintainable. Yes, this is against an IA order, is maintainable. There is no representation on behalf of the petitioner. This is a matter for dismissal on 6th of August.
Grateful.
Yes,
Cell number 118. Mustaq Ahmad.
no representation for dismissal tomorrow.
Cell number 119.
Appearing for the
For the
respondent.
petitioner.
Lord, my instructions are that the main matter itself has been disposed of on 24th November
24th?
24th November 2024.
It is submitted that the main MC
My lords,
itself is
it may
disposed.
be taken up on Wednesday, my lords. I will verify
If there is something, you can come up with an application. Land counsel appearing for the respondent submits that already the main MC itself is disposed of on 24th November 2024. Hence, nothing survives for consultation in this writ petition. Accordingly, dismissed as withdrawn. Before that, land counsel for the petitioner submits that he'll get instructions in this regard. If the matter is not disposed of on the day, the petitioner is at liberty to file an application to revive this petition. Yes.
117, my lord. Just now it is called, my lord. I was not able to follow it. My lord, the office objection is not correct. The writ petition is maintainable.
That's what I said. Why they are showing it like that? And posted it for dismissal because you are not there.
My lord,
List the matter on the same day, not under the caption dismissal. Oh, next. That is 117. 117 or what is the number? Yes.
Sale number, hearing on interrupted application, sale number 120.
And for the respondent, your petition.
Yes.
400 days delay, my lord. My lord, they are not compliant with the interim order. They are not obeying this order of this court. Then they don't have. My lord, they are only insisting the payment, my lord. They are not ready to join the company of the petitioner, my lord. This is the ex parte order, my lord. They is to look into the husband's view also, my lord, because he is a delivery boy in the courier service, my lord. He is fetching 9 to 12,000 per month, average 10,000, my lord. So he is ready to take her back, my lord. So this is the position, my lord. At least they is to refer the matter for mediation, my lord. There may be solve the problem, my lord. This is the each time they are demanding money. That's all, my lord. Because they used to cooperate, my lord. Even advocate also, my lord. Because
Why you drag the advocate in between?
Because my lord, each time they are only money like that, my lord. Because my lord, there is in every family there is a problem. The problem is not to that extent, my lord. In this case, because I come to know that inquiry the petitioner, my lord. Some differences is there. That difference is not that much of.
Then you use your best this thing and settle the matter. Who is stopping you?
They used to cooperate at the same time, my lord.
That's what,
because my lord only.
It's not about he cooperating. The party has to cooperate. Please. What is that he can do?
They used to insist, at least, my lord. We also at the same time. What is the consequences like that?
According to you, he is not interested for a compromise educated.
At least, my lord, tomorrow I present my party, my lord. The director present their party. At least some consolation. Please. My lord. No.
MC is filed.
No.
You have not filed MC.
No. MC is filed by me, my lord. Restitution of conjugal right filed by me, my lord.
What is the difficulty in joining the husband?
Madam, there is also a 490.
No, we will see that all will be there. All will be there.
In spite of criminal case, I am ready to.
Have to talk. Please wait.
Please talk to my client.
Whether she is interested to join the husband or not.
I will communicate with my client.
We'll have it on next
Kindly
Monday.
direct the petitioner to comply
Already
with the interim order.
vacated, if I remember on the
There
last
is no interim order, ma'am.
You can find your SP, no difficulty for you. So please find out from your client whether she is interested to join the husband, if on what grounds, on what conditions.
I will communicate
next week
with her and I will next week.
Next Monday.
Please, my lord.
List the matter on next Monday.
My lord, and the meantime, they are filing the recovery proceedings, my lord. Kindly, to that extent, not to precipitate. 1 week, my lord.
No.
1 week, please. I am requesting. 1 week.
If you want, if you argue on that, I will dismiss this idea of 1 of 24 to cut down the delay of 400 days.
Next month.
Yes, next.
And direct the parties to be present on that day.
No. Let him get instructions first.
Please. Watch out.
121 G Ramana.
For respondents, my lord. We have filed an IA number 1 to vacate the interim order, my lord, which has been given by this honorable.
Counsel for the respondent is present, no representation for the petitioner. List the matter on 12th of August under the caption for dismissal.
Sale number 122 Basavaraj R. Bannur.
No representation for dismissal. Dismissal tomorrow. 122 tomorrow.
Sale number 123 preliminary hearing Chandrasekhara K.A.
No representation. for dismissal. Why it is for preliminary hearing when there is no notice served? Oh, it's coming, it has not come up till now, 2022 writ petition. No, that is complaint, 2022 matter, no complaint. List this matter for dismissal. No representation for the petitioner tomorrow.
Cell number 124.
Yes, no representation
Shankar.
for dismissal tomorrow.
Cell number 125.
Hearing for the petitioner, my lord.
Manjunath.
My lord,
Anything serves for consideration in this petition? Which year is the MC? Take it. Criminal miscellaneous IA of 2018. Principal Judge Family Court at Bangalore. Is it pending till now?
yes, my lord.
It is pending.
My lord, here the maintenance we asked for 1,50,000, my lord. And the petitioner is, the respondent is paying only 50.
What is the stage of this criminal miscellaneous? List this matter tomorrow by the time. Land counsel for the petition should submit before the court. What is the stage of the criminal miscellaneous? And this writ petition of 2022 till now. Notice is not even ordered as the petitioner has failed to comply the office objections and the matter is listed and for preliminary hearing today. Yes, list the matter day after tomorrow. Yes.
Cell number 126.
Yes.
Mohana.
Filing memo, my lord, the main matter itself disposed of, the respondent is also passed away.
It is a memo is filed stating that the MC number 72 of 2019 is disposed of on 10/11/2022 as and as a respondent is no more. Accordingly, memo is taken on record and dismissed as withdrawn. Next 127.
127.
Same dismissal tomorrow.
Cell number 128.
My lords, for the petitioner, I prayed for a week's time, my lords. I need instructions, my lords. If there is a chance that the MC has been disposed and the divorce is granted, I need to verify once, my lords.
For that 1 week is not required. Online also there is a portal which you can matter tomorrow.
Please.
Cell number 129.
Lord, petitioner in the connected petition. Lord, this is regarding to, my lord, the orders passed under section 24. My lord, there is a possibility of settlement. My lord, my client himself is a judicial officer. May I request, my lord, kindly have this matter after 4 weeks. My lord, I will get the instructions. My lord. I have
What
paid,
is happening from
my lord,
2022? We can't.
my lord,
extend the
evidence.
matter.
It is the further evidence of the plaintiff petitioner
Whatever
only.
it is, whatever is the issue before this court, that
My
we
lord,
will decide.
only under section 24, my lord,
That we will
25,000
decide. Why
has
should
been
we
ordered.
keep pending?
Yes, my lord, the last week only, my lord, they have given the
This is
proposal
matter
for.
finally a week's time is granted at the request of the petitioner. No further adjournment. Yes, next 130.
130.
The main matter is posted to this month 31st for judgment. The matter may kindly be taken up
No,
first.
why? What is the relevancy that when the matter is posted for final hearing that we should not hear? Not even notice is served.
Notice
in
is not, sir.
2022
Notice is
matter.
not, sir. It
Give
has-
that, let us see, please argue. Where is the impugned order? Page number?
Impugned order is at page number.
Yes. What is the amount granted by the court?
Annexure N.
Yes. Annexure?
N.
The respondent is directed to pay rupees 10,000 per month to petitioner number 1 and rupees 5,000 to petitioner number 2.
Yes, please.
So 10,000 and 5,000.
15,000.
What is your income?
My income is just 32,000 rupees per month.
Huh?
32,000 rupees per month. And I have produced document before the trial court that the petition is working.
Please come to the reasoning part. Are you complying with this order?
I have been paying.
Yes, please come to the order. Come to paragraph number 10.
There is separation being mentioned in paragraph number 10, please.
11.
11, since the respondent has not made any arrangements for maintenance of the petition, just necessary to direct the respondent to pay into maintenance of the petitioners. The court has not even looked into the fact as in paragraph number 12. As far as the quantum of maintenance is concerned, the petitioner has paid for maintenance of 50,000 per month. However, the respondent has declared his income as 32,000 per month, but the document read upon the respondent show that he has paid income tax more than 3.5 lakhs per annum.
Please come. This is an order. The present writ petition is filed, agreed with the orders passed in I number 2 in criminal miscellaneous number 426 of 2022, dated 3rd September 2022. The matter is coming up for preliminary hearing. That is a writ petition of 2022 in 2025. Land counsel for the petitioner submits that as per the order passed by the court, an amount of rupees 10,000 to the first petitioner and an amount of rupees 5,000 to petitioner number 2 is paid towards the interim maintenance. He is ordered and he is paying the same.
In my 131, I appear for the respondent. As per my instructions, arrears is there, they are not paid in full.
130.
That
130, yeah.
130 being taken.
that he is continuously paying. It is submitted by the land counsel. The petitioner is, the main matter is coming up for,
31st July for judgment.
it is coming up on 31st July for judgment. The petitioner is complying with the order from the complying the same and paying the maintenance according to the petitioner from the date of order. And already the main MC itself is heard and posted for judgment. At this point of time, this court is not inclined to go into the merits of the matter, and accordingly, without expressing anything on the merits of the matter, considering the fact that the main MC is posted for judgment, this petition is dismissed. Yes, next.
Cell number 131 for addition matter.
Millets, for serial number 131, I'm appearing for the petitioner Millets. May I request the matter to be taken up next week with some personal inconvenience? In fact, Millets, in this matter, it was referred for mediation. I have 2 landed properties. Both I have offered them to be taken up. Millets, the petitioner has suffered with stroke. He is not earning.
Counts for the petitioner lists this matter on 19th of August. No further adjournment will be granted. Yes, 132.
132.
Appearing for the respondent, my lord, I have informed the other side is seeks commendation, my lord, since the counsel who is appearing the matter is suffering from fever, my lord.
It is submitted with the counsel with the respondent is unwell. Lists the matter on what is the earlier date on 19th.
Cell
Yes.
number 133.
No representation for dismissal tomorrow.
Cell number 134. 134. Deepa J.
No representation on behalf of both the parties for dismissal on 4th.
Cell number 135.
In this matter, parties are residing together, my lords, they settle the matter.
It is submitted with the land counsel to the petitioner that both the parties are residing together and no further orders are required to be passed in this petition. The council's representation is the council submission is taken on record and both the petitions are dismissed. As
Obliged.
instructions. Yes.
Cell number 136. 136.
No representation for dismissal on 5th of August.
Cell number 137.
Appearing for petitioner, my lordship, there is an interim order by this honorable court which has been complied, my lordship. There is an interim order which has been complied, my lordship.
Interim order?
Which has been complied by the
No, you
petitioner.
comply, you have to argue. It's RPFC of 2019.
Yes,
Pass over, argue in the afternoon.
next week, my lordship.
No, pass over in the afternoon.
Kindly have it next week, my lordship.
Hmm?
Kindly have it next week, my lordship.
Next week you will not ask for adjournment.
Next
You will
week.
ask. You will ask for adjournment next week also.
No, my lordship.
This is matter next week, finally. The list on 6th at the request of land counsel the petitioner. That day you argue and dispose it off. Yes.
138. Kumar KG.
We wait next week, my lords. It's a dismissal order, my lords. 127 proceedings were dismissed. Next
Why
week,
next week? 2019 RPFCs
19
are
matter.
listed for hearing.
Family matter also they have, but they said, my lord, yesterday I called.
they said it's the petitioner respondent is from Tamil Nadu. There they have filed family matter. My lords, we have to contact the
No, the
person.
notice is served on the respondent.
Have servo, is
We will
servo-
look at the interim, the
No, my lords,
interim order.
This is the order, my lords, dismissal order passed.
That's
under
what,
the-
whether it is right or wrong, that's what we will
Lords,
decide.
I'll get instruction, my lord, next week, any date, my lords, I'll add.
Same like the earlier matter, no
Please.
further adjournments.
Please.
Yes, 139,
Sale number 139,
no representation for dismissal tomorrow.
sale number 140,
The petitioner, your lordship, filing a memo to withdraw the petition.
Take that. Memo is filed, seeking to withdraw the petition. As the petitioner is not interested to prosecute the matter, accordingly, this memo is taken on record and dismissed as withdrawn. Yes, 141,
141, 141,
no representation for dismissal tomorrow.
142 disposed, 143,
No representation for dismissal tomorrow.
the 144,
This matter I'm for the petitioner, my lord. Like it is my instruction that, my lord, they have settled the matter. But you will ask me kindly out and next week, my lord, we will report it.
Matter on 29th.
Grateful, please. Interim order, my
Of and counts for the petitioner. It is submitted that the parties have settled the matter amicably. By the time, if the petitioner is not in a position to get the instruction, the matter has to be heard.
Right.
Yes.
Interim order may kindly be
The
extended.
earlier granted is extended.
Grateful.
145, TV,
For
Consent
dismissal
order.
tomorrow, no representation.
sale number 146,
The petitioner.
Sandesh B. Nadigan,
My lords, I was informed that the matter is settled, my lords. My lords may have it next week, my lords. If it is settled, I'll file a memo along with signature of the petitioner.
Or we will say that it is your instruction that the matter is settled. If not, you can file an application for revival of the same.
Please.
Land counts for the petition submit that the matter is already settled between the parties. And they would get instructions in that regard. Considering the submission that the parties have settled, the petition is dismissed as instructions. However, in case if the parties have not settled, the petitioner is at liberty to file an application seeking to revive the petition.
Grateful.
Yes.
147, KL Srinivas,
For the respondents 1 and 2.
Where is the petitioner? Counsel for the respondent is present. No representation for the petitioner. Lists the matter for dismissal on 30th.
Much of.
sale number 148,
Petitioner.
Gopal Krishnamurthy.
This matter, my lord, we have tried for the settlement before the mediation center Bangalore,
Did
but
you
that has
approve?
been failed. So now, my lord, we are ready to proceed with the matter on merits. And moreover, my lord, there are 4 matters are pending before this honorable court, including this RPFC. And today, my lord,
What are the other numbers?
my lord, that is division bench, my lord, because MFS, my lord. Kindly extend the interim order today for the reason, my lord.
Counsel for the petitioner is present. No representation for the respondent. List this matter on 31st of July. Tell them the interim order granted is extended.
Please, grateful.
Yes.
149, Prasanna VR,
In this matter, my lord, the petitioner has got communication from the respondent side that he is willing to settle the matter, my lord. Therefore, 2 weeks time may kindly be granted, my lord.
Finally, 2 days time is granted.
2 weeks time may be granted, my lord. Settlement talk is going on.
2021 writ petition, and when the matter comes in 2025, for everybody settlement talks
But
will go on.
the husband has already got married, second marriage, my lord, and got 2 children.
He is not even
Therefore-
representing before the court. He is not even representing.
Yes, my
Notice
lord,
is
but
served.
he has filed the
Finally,
MFA.
2 weeks time, no further time will be granted.
Much obliged.
sale number 150, RB Deshpande, PB Umesh,
No representation for dismissal tomorrow.
sale number 151,
Same order.
sale number 152,
Same order.
sale number 153, and Satish Chandra,
The petitioner and respondent got in already divorce. Divorce
What
is
divorce?
Divorce is completed. Now she filed in a 125 application for the maintenance.
125 proceeding.
Huh?
What is that?
125 application. She's the present is in a lecturer in a government college and got in a PhD. I am also in a lecturer in Mangalore.
How much is the maintenance granted?
15,000. Because I am ready to one-time settlement also, but she is not ready to cooperate.
No, I'll ask my client and
No, it is under 125 CRPC proceedings.
Yes.
You are working, you are independent. Why should you be granted? Why you have filed a petition under 125?
earlier
When you are working,
She's a
No,
PhD graduate.
I'm working in lecturer is madam, but I'm a temporary lecturer, not a permanent employee.
but you are earning. That's the point.
No,
That's why-
he produced the P&L and he is admitted and salary certificate is also produced. What is
No,
there?
will-
I got a second marriage. I got a child.
I'll ask
How
my
can I
client and,
maintain all these
confirm.
things?
It is submitted by the counsel the petition. The respondent is well qualified, working, and still she has filed an application of 125 CRPC. The petitioner is married and also has the responsibility to take care of the wife and the child. When counsel for the respondent submits that, he'll contact the client and will come up with instructions whether there is any possibility for a one-time settlement. Does this matter when?
Otherwise, they should appear before the court. I am also instructed to, my client is also appear before.
Both the parties shall appear before this court on 30th of July in the
No,
chambers at
next-
5 o'clock.
Next month, madam.
No, 30th of this month.
Allah, because he's got an leave and everything from Bangalore. Minimum
You want a longer date?
15 days I need a time. I inform.
Then 12th of August.
Much of this.
Yes.
Cell number 154 disposed, 155.
Appear for the respondent, my lord. The matter is settled between a husband and wife. Husband has told that he will pay 5 lakhs in his 2 installment.
Yes.
And
My lord,
wife
now
has
only
agreed for
done-
it. She is before the court. She has agreed
Why
to
don't you reduce it to writing?
My lord, now only my lord terms are fixed. My lord,
After tomorrow?
no, my lord. He first installment he wanted to pay my lord a sum of rupees 2,50,000. That is the reason 13th or 15th, your lordships kindly. By that
It is
time,
submitted that almost,
I will make arrangement.
Almost the disputes are on the verge of settlement. It is submitted and then both the councils seek time till 15th of
14th of
August.
August, please.
It says that the matter may be listed on 14th August. List the matter on 14th. Next 156.
On that, we will file a joint.
And by the
kindly
time they'll
record
come
it.
up with a joint memo.
Please.
Yes. Yes.
For the respondent.
There is a counsel for the petitioner.
Maruti P. Nataraj.
No representation for the petitioner. List this matter for dismissal on 22nd of August.
Cell number 158.
157, what?
157.
My lord, in this
Saraswati.
matter, I appear for the petitioner wife, my lord. She has filed his petition for enhancement, my lord.
Respondent is served.
Yes, my lord, he's
Please.
placed ex parte. Even before lower court, he was placed ex parte.
Let's see.
my lord.
Where is the impugned order?
The impugned order is at page number, kindly take page number 11, my lord.
Page number 11.
Paragraph number 10, my lord.
Your petition is dismissed.
No, my lord, the court has
Court
awarded
granted
3,000, my lord.
3,000. How much you have claimed?
I had claimed 10,000.
Let's see. Come to the reasoning part. Let us.
My lord, page number 11. I'll come directly to page number 11, my lord. Page number, paragraph number 10, my lord. The evidence given by the petitioner regarding ill treatment method, so and so. Then, my lord, on the next paragraph, no material before the court to come to the conclusion the petitioner is able to maintain herself and she has source of income to maintain her. Though the petitioner has deposed the respondent is having source of income to give maintenance, but no documentary evidence is produced. That's correct, my lord. I have not produced any documentary evidence, my lord. But he has a business.
So how do you prove that?
I was only by way of oral evidence I could.
Please
only-
come. Agreed with the seeking enhancement of maintenance. The present petition is filed by the wife, agreed with the orders passed in C miscellaneous number 648 of 2014, dated 23rd June 2016, whereby the court had granted maintenance of an amount of rupees 3,000. The petitioner herein has filed a petition seeking maintenance of an amount of rupees 10,000. It is the case of the petitioner that the respondent had failed to take care of her, and he's running a hotel business, and he owns land, and he also owns a landed properties, and he's earning 30,000 per month. The court, by order impugned, had granted only 3,000 per month as maintenance. While granting the said amount, the court has observed that though it is a case of the wife that he is earning 30,000, there was no evidence placed before the court. The court, considering the fact that even considering the daily wages, as that he's doing a coolie work, and if he's earning 10,000, and considering it as 10,000, the court had granted 3,000. Before this court, as well as before the trial court, there was no representation on behalf of the respondent, and the trial court has passed an ex parte order. When the wife files an application seeking maintenance, the burden lies on her to prove what is the income of the husband, particularly in the light of the fact that the husband has not represented in this matter. Except the oral assertion that he is earning 30,000, there is no any other evidence on record concerning the same. The court had granted 3,000, and this court finds no reasons to interfere. Accordingly, dismissed. Yes, next.
Number 158. Mohan BK.
Dismissal tomorrow.
Cell number 159 disposed. 160. 160. Peter Narayan.
I appear for petitioner, madam. My lord, annexure is.
For the respondent
is challenge. That is the order under section 24 for
Page
it.
number?
Page 58, annexure E, page 38. Page 38, annexure E. Well, during the pendency of this petition, my lord, I have gathered an information
let
that,
me
my
look
lord,
at the
the
order.
main MC petition is disposed of.
When?
13/10/2022.
10/2000.
13/10/2022.
Submitted with the land counsel for the petitioner that the main MC itself is disposed of on 13/10/2022, hence nothing survives for consideration. Accordingly dismissed. Next.
Please.
Number 161.
Yes.
Appear for the petitioner. Madam, ನನ್ನ ಹೆಸರಿದೆ ನೋಡಿ ಒಂದು ನಿಮಿಷ. ಯಾರ ಹೆಸರಿದೆ?
That is Ramesh RM.
I'm sorry.
Yes.
Nagamani.
file. This is a writ petition of 2022. No representation for the petitioner. This is matter for dismissal tomorrow. Yes.
Cell number 162. Pradeep.
2 weeks time will be granted.
Right.
Malaj, there is a slight inconvenience, Malaj. Senior is out of station. Senior is out of station, Malaj. Any date, Malaj.
You can argue,
Needed after the
please
next
come
week,
and
Malaj.
argue. It's a 2022 matter. This is a
Malaj,
matter tomorrow.
Malaj,
Yes,
a
next.
week's time may be granted, Malaj.
Why there should be a reason? Why senior need not come for a writ petition? You should be able to argue.
It's not
We'll
that
see.
much.
If you are not able to, then we'll accommodate. This is a matter tomorrow,
It's not that, Malaj. Kindly have it on Monday, Malaj.
day after tomorrow.
23rd.
Yes.
Cell number 163, 164 disposed. Cell number 165. Is it there?
The matter challenging for the domestic violence wherein the 2000 is awarded. So Lordship, now the domestic violence still is pending. So during the pendency also, she also filed the 125 Lordship. So the
So this
latest
impugned
file,
order is arising out of which proceedings?
Lordship is, pendency of this DV also, she filed one more 125. So wherein she got the order by latest Lordship and dated 3/7/2025 in Mysore, sitting in the third additional judge, seeking that and accordingly the Lordship
No,
is,
first please tell the court where is the impugned order?
input order is 2000 was there, she seeking for the enhancement.
Yes, where is that order? Page number.
Petitioner is filed, I am the respondent.
You can also assist the court, though you have
Please,
not filed
please.
the petition.
Please, please. That is annexure 5 Lordship.
The
Page-
application under
page
section
at 36.
24 is dismissed.
Please.
Application is dismissed.
Yes, yes.
Against a dismissal, wife is before this.
No, no,
court.
application is allowed and then 2000 rupees order is passed. 24 of the filed the petitioner says against the respondent number 1 and husband and hereby dismissed.
Where do, that's what is dismissed. No representation for the petition. This is matter for dismissal tomorrow.
Great.
Then number 166.
Appear for the petitioner, my lords.
Yes.
Respondent, my lords.
As husband's petition.
Objection statement is ready, my lords. I will file the copies. Your lordship.
What is that?
Objection statement is ready. my
What
lords.
objections for the writ petition when there is an interim order by the, when already an order is passed by the court? This court is not looking at any new material. Please come to the impugned order.
My lords, husband's petition, my lord,
Oh.
challenging the quantum of maintenance
How
awarded.
much is granted?
12,000 is granted, my lords.
What is your income?
My lords, my income is 88,000.
Then
And
what's the difficulty?
my wife is also working.
How
She
much
is-
is earning?
She is earning 1,55,000.
No, my lords.
That the record is there.
Mm.
Assets and liabilities have been filed by both the, and the entire burden of maintaining the kid is bestowed upon the husband. And the other factor is she has filed this application under section 24. And child is
What
not
has
made
happened to this MC? It's pending.
pending.
Let's see the reasoning part. Come to
Please.
the order.
Please. Page 8, running page 18, internal page 9. ma'am.
Please read.
In order to appreciate for grant of interim maintenance in matrimonial proceedings under section 24 of the Hindu Marriage Act, it is necessary to mention provision section 24 of the Hindu Marriage Act. Section 24 of the Hindu Marriage Act contemplates that either husband or the wife has no independent income sufficient for her/his support and the necessary expenses of the proceedings. So on the application, the court may pass an order for payment of maintenance and expenses having
No,
regard
it
to
is
the.
for the child and for herself.
Lords, no, the 24 is only for for herself. If she had filed under 26, then she can also seek for the child. This
Forget about the
provision, my lords.
But ultimately you are liable to pay to the
My
child.
lords,
Yes, my
she has not even made child as a party to the proceedings. She has filed on her own.
But fact remains, she is taking care of the
Yes,
child.
yes.
15,000 for his, what is the age of the child?
Presently, 7 years, my lords. She is studying in first
7
standard.
years. 7 years.
And I have filed for
We'll
announcement also.
record it that it's for the child. Please come. Agreed with the orders passed in I number 2 in MC number 1472 of 2020 dated 4th February
Oh, my lords,
2022.
I have learned that she has filed one more application seeking for enhancement of this maintenance.
Reason is, my lords, I will submit.
Where is that application?
Before the Honorable Family Court, I have
That too,
filed.
that she can, she is
There
entitled.
I have filed assets and liabilities also. And my lords,
No, I am confirming this order. By the orders passed in I number 2 in MC number 1472 of 2020 dated 4th February 2022.
My lords,
Whereby the
my
court-
presence may be excused.
Whereby the court had granted an amount of rupees 12,000 per month towards interim maintenance of the child from the date of filing the IA, that is 12/3/2022, 2020 till disposal of the case. The husband is before this court. parties are referred to as the wife and husband. The wife had filed the IA under section 24 of the Hindu Marriage Act, directing the husband, seeking a direction to the husband to pay interim maintenance of 75,000 per month to her and the minor daughter, and rupees 1 lakh towards the litigation expenses. The family court, by order impugned, had granted maintenance of an amount of rupees 12,000 per month to the child. And when it comes to granted only maintenance to the daughter. The only objection, that is the technical objection that is raised by the petitioner before the court, is the wife or not, wife can only seek maintenance under section 24. Under section 24, she cannot seek the maintenance to the daughter, and daughter is also not made as a party. Court had granted the maintenance to the daughter, observing that these kind of technicalities cannot come in the way of the court. And admittedly, both the parties are earning. The court observes that the income of the wife is 88,000. According to the wife, it is 88,000. Income tax return for the financial year 2020-2021. It shows that it is 1,55,025. And the respondent's income is what is the income of the
My lords, that day on 88,000.
petitioner?
Lords, net income is around 1,21,000.
No, my lords. According to, I have filed
Your income, what is your income?
Lordship, in page number 26, your lordship.
Page number?
26, your lordship. In page 26, internal page 17.
And
net income of the
net income is 1,21,639, and after deductions it's rupees 65,877. Looking at all these aspects, the court had granted 15,000 maintenance to the daughter. Land counsel appearing for the petitioner had argued before this court in the similar lines that has been argued before the family court. Family court, land counsel and submits that the writ petition needs to be allowed. Land counsel appearing for the respondent submits that court had rightly considered and granted the maintenance and no interference is called for. Next, having heard so and so. The only objection that is put forth by the petitioner is purely a technical objection. The court has granted maintenance to the daughter. It is undisputed, the relationship between the parties is it's undisputed, and it is the obligation of the father to take, it is equally the obligation of the father to take care of the child. Considering all this, the court had rightly granted an amount of rupees 15,000 as maintenance, and this court finds no reasons to interfere. Accordingly, dismissed.
Number 167, VM Halaswamy, petitioner. The deepest.
For respondent number 1, my lord, a short date may be fixed. Here is not well today, my
For
lord.
petitioner in this
It
case,
is
my
a
lord.
suit.
Well, on short accommodation maybe one, my lord.
Why short accommodation for a writ petition of
My lord,
2020?
senior is not.
For writ petitions of this nature, seniors need not come.
My lord, on short date maybe. It's quite complicated matter for me to argue.
Hmm?
My lord, it's quite complicated matter for me to argue, my lord. One short date may be given.
Interim order is there.
Yes, my lord.
If both of you are not agreeable, court is also, list this matter on 13th of October. Interim order earlier granted is extended till then.
Much obliged.
Cell phone 168. MRE method.
Appearing for petitioner. 27/9/2019, the petitioner filed a divorce petition against the respondent under section 13(1)(a) and 13(1)(b). Thereafter, 23/12 and 2020, the respondent filed a application under section 24 of Hindu Marriage Act for interim maintenance. The application is partly allowed. She was seeking 15,000. The court passed a order for 3,000. But she filed a assets and liabilities by suppressing the real facts. Now she is working as a technical assistant in the KSRTC. She is having a more than 45,000 per month.
Only maintenance is only to the wife or daughter also?
Yes, my lord.
Maintenance is only to the wife or daughter also?
Both, my lord.
Court has granted how much? 10,000.
3,000, my lord.
For that you are before this court. You are
No, my
questioning
lord.
that order of maintenance 3,000.
Yes, but
On submission, both the cases are disposed of in the trial court. The distribution became
What is that
infrastructure.
MC number?
MC number 152 by
MC
2019.
for, who filed the MC?
Husband.
What you are
I
saying?
have filed a section 24 application. There may be order has to be passed per month 3,000.
In the
He
MC you
before-
filed 24 application.
Yes.
The MC, when is it disposed of?
On 21/7/2022 for non-prosecution.
2000?
21/7/2022.
It is submitted that the main MC itself is dismissed for non-prosecution on 21/7/2022. In view of the same, nothing is otherwise for consultation in the said petition, accordingly dismissed.
Cell number
Yes.
169.
Yes,
Short date.
no short date, please argue.
Jagdish.
Not should kindly pass over.
Pass over.
Cell number 170. Harish Bhandari T.
It's a matter, Your Lordship. After accomplish file is missed, Your Lordship, in the office. This is a case where Your Lordship, wife files a petition one under Domestic Violence Act.
Let's see the impugned order.
And one, Your Lordship, for maintenance.
Hmm.
In Domestic Violence Act, Your Lordship, the court orders 20,000 rupees.
How much
20,000 rupees to the wife.
in this petition?
In this petition, Your Lordship, the 20,000 plus 15,000 each to these two sons, daughters.
3,000?
20,000 in domestic violence.
Uh,
20,000 in this matrimonial case, MC case, maintenance case.
No.
Domestic violence case in 20,000 is ordered by the court.
That's what I'm saying. 20,000 in DV,
Yes,
20,000 in MC to the wife.
wife, 15,000 each to,
Children. So 30 plus 50 plus 20, 70 is
Yes,
you're
yes.
paying.
that has to be paid.
What
This-
is your income?
I have foreign returned person, Your Lordship. I am senior citizen.
What is the age?
So somewhere 65, 67, Your Lordship. That's why file I don't see.
With the request
This
of-
court has modified, Your Lordship. It is to
I
the,
think we can dispose it of 22 matter. This is a matter on 12th of August, no further adjournments.
171. Nirmala K. For petitioner.
Is
Gautam.
arising out of MC petition, my lord. My lordship, it is, I am representing the husband and she has filed a application under section 24 of Hindu Marriage Act.
What is the impugned
praying
order?
for-
How much is granted?
Praying for litigation fee.
The
expenses.
petition is directed to pay 5,000.
Lordship, that is our operating position is 21, page number 21. And
5,000 per month towards maintenance and litigation.
it is
How
not
much you have
maintenance
claimed?
for the,
How much you have claimed?
I'm paid, I mean, I'm getting 5,000 rupees per month. The page number 27 is the salary certificate. That's a translation version. And 28 is the salary certificate of the respondent. And she is working and she is a B.Ed and BA graduate.
This is.
She is only praying for the litigation expenditure, my lord. Kindly, the annexure B, that is the page number
She
22.
wanted 15,000 per month. Court had granted
5,000 per month.
litigation expense.
Litigation.
Who appears for the respondent?
Notice as well.
The counsel for the respondent is not present. Counsel for the petitioner is present. List this matter on 4th of August.
Cell number 172.
For the petition, my lord.
Nanesh
Next
Kumar.
week, my lordship.
Why? These are all old petitions. We should not keep it pending. Why a writ petition be kept pending?
Without fail, I will argue,
Interim
madam. Next
order.
date, my lord.
Huh?
Next week, madam. I will, without some.
Again, all these matters
No,
have
no.
to be listed. Why? You should be ready when the matters are listed. That to what argument will be there in an interim maintenance application? Hardly it takes 2 minutes to argue. Even right now, you can open your file and we can look at it. You have the file?
No, that is the issue, my lord.
This is a matter on 29th, no further adjournment.
Please, oblige me.
Cell number 173.
I pay for responding.
MP Chandrachуда.
Tomorrow, no representation for the petitioner.
That's day after tomorrow.
Day after tomorrow.
Cell number 174.
For dismissal tomorrow.
Cell number 175.
Yeah, for the patient in this case. Respondent. But as the respondent not has voluntarily went to left the matrimonial home, he filed a petition under section 9 of the Hindu Marriage Act, which was contested and came to be decreed. She did not turn up. Then a petition under divorce of 13(1) A, B has been filed for under the provisions of dissolution. But in which she filed an application under section 24 of the Hindu Marriage Act seeking maintenance. On the other hand, she filed a petition under 125 showing wrong address of the petitioner and obtain an interim order.
Are you entitled during the pendency of those petitions for interim maintenance when you have willfully deserted the husband?
Oh, that is disposed of.
Which one?
That criminal miscellaneous is not paying in that criminal petitionals.
Oh, no. He has filed for restitution. Restitution is allowed.
Yes, my lord.
Then thereafter he filed divorce. Thereafter he have filed divorce. In that you have filed a petition for interim maintenance.
Yes. Not in the petition. Earlier, before filing the divorce petition, she filed a criminal miscellaneous petition for the maintenance.
Where is the order? Let's see.
At page number, annexure E, at page number 52, my lord.
Annexure E is the final order in a maintenance petition under 125. Where
No, what is impugned in this?
impugned in this writ petition interlocutory order passed by the
Where is
family
it?
court.
Page
Annexure
number?
A.
Annexure E. Page number 12.
This is a
Operative
petition
portion.
filed by the petitioner under section 9 of the.
No, this is not
Sir, for
13(1)(1)(b). 13(1)(1)(b).
For aid filed with the respondent is hereby partly allowed with cause. Yes, what do you say? How are you entitled? When is the decree in restitution?
Restitution annexure B dated 11/1/2018.
After that you file this MC?
Yes, my
How are you entitled for maintenance?
No, the section 24 for interim maintenance, my lord. Because husband himself is harassing the petition, the respondent, so she did not joined. Then only he filed the divorce petition, because earlier there is a order for the maintenance. He is not paying that maintenance also. Then only.
The other day, this is the judgment is no bunch of judgments were denied. Latest judgment of Justice Sanjay Kumar. Not the main, not this one.
And the present impugned order is also very clear.
Oh, the other day what was this? No. That divorced wife after marriage and before divorce and after divorce. 125(4). which is latest judgment is there, Sanjay Kumar.
Lord, this improvement is very clear. On page number 18, the trial court ordered if any is he has already paid any maintenance in another case, that should be deducted in this case. There is order, my lord.
Now the question is about entitlement to maintenance. We are on that point.
He filed for divorce and she filed for interim maintenance under section 24. That in that he is not paying, even not a single pay is paid in that criminal miscellaneous. So that's why she filed this interim maintenance.
Yes, I'll pass orders. Take the judgment. Pass over, I'll pass order. Yes, next.
Cell number 176 urgent, 177, 177,
No representation for dismissal on 12th of August.
cell number 178,
I am appearing for the respondent, my lord.
Ravishankar S.
Yes.
So original MC petition, my lords, was allowed, filed by the petitioner. Divorce is granted, my lords. In the earlier occasion, my lords, 21/7/2023, I filed a judgment answered by the trial court, my lords. Now, in this case, my lords, the execution proceedings were stayed, my lords, for not to precipitate the order.
What is order impugned?
21/7/2023, my lords, the order was passed.
21/7?
2023. The sandalwood.
21/7/2023 order.
No, the sandalwood granted the interim order, my lords.
I'm asking you, where is the impugned order?
I filed in the memo, my lords, on 21/7/23.
Impugned order will be filed in this.
Impugned order, impugned in this judgment. Subsequently, my lord, main case was allowed, my lords. MC petition.
This has virtually become infructuous, my lord.
Please,
The IA is disposed of.
So that I understand. Why this court has granted stay of execution, that I'm not able to understand.
No, that time MC was pending, my lord.
Where is the impugned order? Please show.
Annexure E, my lords.
IA number 8.
In the, as per Annex 3, my lords, page number 43, passed on 5,000 for maintenance to the wife, my lords. Up subsequent to that order, my lords, I made this petition.
Where is the impugned order? I'm not even able to see that. You are mentioning in your grounds for interim order, or stay of the order dated 19/1/2022. I find an order at page number 59. It is dated 21/2022.
Please, my lords. Order portion is page number 43.
43.
Original petition, page number 43.
5,000 is granted.
Please, my lord. Subsequently, divorce petition was allowed, my lords.
Where is that?
I filed one memo, my lords, on 21/7/23 in that.
There is a memo.
In that judgment. Hence, my lords, kindly have it, and day after tomorrow I will file memo to withdraw the petition because that execution petition is pending, my lords. In the, as per that, we are not. I am not entitled to pay anything, my lords.
The present petition is filed. Agreed with the maintenance granted by the trial court. It is submitted that during the pendency of this petition, the main MC itself is disposed of on 15 June 2023. Hence, nothing survives for consideration in this petition. Accordingly, dismissed.
Please.
Yes.
Cell number 179.
My lords, I'm appearing for respondent. My lord, the main GNWC case 24 of 2020 itself has been dismissed for non-prosecution on 1st February 2023. So
First
this
February.
petition has 2023 itself. This petition has become infectious.
Main GNWC itself is dismissed for non-prosecution on 1st February 2023. Hence nothing survives for consideration. Accordingly dismissed. Next.
180. Cell number 180.
Appear for the petition.
Aditya.
Pray for a short accommodation.
Why?
Counsel on record is unwell, my lord. Henceforth, a short accommodation. Any date this
No
week.
representation for the respondent. Learned counsel representing the petitioner submits that the counsel is unwell. This is the matter on 18th of August.
Achha.
Number 181. Manjunath G. Kandekar.
No representation for dismissal tomorrow.
Cell number 182.
Appearing for the petition, my lordship.
Adjournment.
For respondent.
Yes. Yes, very simple, not a page number.
Sorry, my lordship, 186.
And counsel for the respondent is present, no representation of the petitioner. This is matter for dismissal on 5th of August. Yes.
Cell number 183. CH-19.
Respond number 3, my lords. We are trying to settle the matter, my lords. I need 2 weeks' time. The respond number 3 is residing at Mysore.
Matter is pending before the trial court settle it. Writ petition of 2022 need not be pending before this court.
One date, my lords, because she is a resident of Mysore, she is not able to come here. At least a
Please do
week's
it,
time, my lords.
Please do it before the trial court. Because on many of the cases, because the matters are pending,
There are at least 4
they're
or
not
5
able
matters, my lords.
to proceed with the matters.
Now, what has happened is there is an NBW. The petitioner will not be able to go there and appear before the court, my lords. So that is the hiccup here.
We can't do anything.
My lords,
We cannot do anything. I have to hear the matter on the merits of it.
at least a week's time, my lords.
Finally, a week's time, no further time will be granted. By the next time, the counsel, the respondent has to argue the matter on the merits of it. Yes.
Cell number 184. KV Satish Chandra.
I appear for the respondent.
I'm appearing for the petitioner, but in the long back, the petitioner has taken the entire case paper and no objection from me. But he's not filed any wakalat for that. And I will give the retirement notice within a week.
Petitioner, counsel for the petitioner submits the party has already taken away the file. He'll file a
They
retirement.
file and no objections are wakalat
Retirement,
also.
no objection also he has taken. He'll file a memo to that effect. List the matter next week. Yes, next.
Number 185.
I appear for the petitioner, my lord.
Yes.
My lord, this matter has become infructuous because on 19/11/2022, non-bailable warrant was issued to the petitioner on the ground that the children were not kept present. Now, my lord, this honorable court had granted the stay. Thereafter, no order has been passed. Therefore, it has become infructuous. Hence, it may be disposed of as infructuous.
To the order.
19/11/2022, page number.
What is the impugned order in this writ petition?
Impugned order is, Lord, on 19/11/2022, petitioner mother was required to was ordered to keep the children present. But on that day, in the school, my lord, some important things were there. The children were not ready to miss the school.
No,
However,
when you say that the petition becomes infructuous, what is the impugned order?
impugned order is the arrest warrant was issued, non-bailable warrant was issued.
A number filed with the petitioner, so and so guardian is dismissed. Page number, where is the impugned order?
Page number 73.
Yes, let us see, please come to that.
Yes. Lord, case, petitioner and respondents are
Issue
present.
bailable warrants for a sum of rupees 1 lakh against the respondent.
Yes.
To keep the 2 children present before the court, as per order dated so and so. And then what? This was questioned before this court. Then what is the order of this court?
This honorable court had stayed this order, my lord. And thereafter nothing has happened. Thereafter the case is being proceeded with, and now it has reached the stage of arguments.
Whether she has, whether the children were present before the court or not.
Thereafter, they were present.
Yes, the order impugned is order dated 19/11/2022, whereby the bailable warrants for a sum of rupees 1 lakh against the respondent were issued to keep the two children present before the court. As per the order dated 29/10/2022 and 3/12/2022, that matter was carried to this court, and the order dated the 19/11/2022 is stayed by this court on 1/12/2022. Then counsel appearing for the petitioner submits that as on the thereafter, after the interim order passed by this court, the respondent is present before the court along with the children, and now the matter is at the final stage of the hearing. Hence, nothing survives for consideration in this petition. Accordingly, the petition is dismissed as the order itself is already worked out. Yes.
Number 186, 183M.
For the petitioner, my lordship.
Waiting for respondent.
My lordship, it's a dispute between the petitioner and the respondent is the DNA test, my lordship. The child was born in 2020. Yeah, the respondent filed a divorce petition.
The petitioner, mother or the
Mother is the petitioner here, my lordship. Respondent is the
order of the
husband.
court?
The trial court has ordered to test, approve for DNA test, my lordship. In his divorce petition, he states that he was tested the DNA privately. It's comes negative. So the lab persons is not ready to give evidence before the trial court, family court. Hence, he needs again he had to test the DNA of the child. So repeatedly, Supreme Court is stating that the DNA of the child it has to be not to be tested because no divorce has been granted. He admittedly the child was born on 2020. He was present. One the allegation is that there is a conversation between the petitioner and the unknown person. There is no name of the person. Anything is stated in the divorce petition. One allegation is that he is talked to some other.
Filed the MC.
MC filed by the respondent, my lordship.
On what ground?
On the ground of he was tested the DNA of the child is it negative.
See the petition. Come to the petition.
Yes.
Para number 10 of the order.
Paragraph number
10 of the impugned order.
Please read that.
Keeping in mind the dictum of law laid down in the above said decision, considering the fact of the case in hand, this court of the clear view that the petitioner has specifically contended that till that child is born, he was under the impression that the child is born to him. Whether the petitioner come to know about the extramarital affair of the respondent with some other person, and after hearing the phone conversation between the respondent and some other person, as per Exhibit P4 CD, then he come to know that the child is not born to him. Thereafter, the petitioner has discussed the matter with the respondent or parents, and then with the consent of the respondent, the DNA test was conducted, and Exhibit P3 DNA test report has been confirmed that the child is not born to the petitioner. Then only the petitioner approached the court seeking dissolution of marriage on the ground of respondent had voluntarily sexually intercourse with some other person. In order to prove the same, he was only left to the petitioner. He has to prove that he is not biological father of the child born to the respondent. As such, he has filed the application for DNA test. It is relevant to note that this court, after hearing the phone conversation between the respondent and the unknown person, also respondent and the petitioner has recorded Exhibit P4 CD. This court is of the clear view that the respondent has clearly admitted her extramarital sexual relationship with some other person, so that it is just necessary to order for DNA test to find out the paternity of the child born to the respondent. Otherwise, it is highly difficult to adjudicate the issue in controversy. Under such circumstances, this court is of clear view that the argument advanced by the learned counsel for the respondent, the application is not maintainable as the petitioner is having opportunity to prove the Exhibit P3 test by examining witness will not find force. In this regard, it is relevant to note that according to the petitioner and the consent of respondent, the exhibit P3 DNA test was conducted. Now the respondent is denying the said DNA test report. So that the argument advanced by learned counsel for the respondent cannot acceptable. Hence this court is of the considered view that an opportunity is to be given to the petitioner to prove the case by way of DNA test. The petitioner has made out the prima facie case ground to allow the IA number 4 as prayed for.
Yes. Yes. What more you want to say?
Lordship. It's only the unknown person against the only phone conversation. Nothing has been identified, my Lordship. Only phone conversation basis he was filed an application.
Lordship, may I make one submission, Lordship?
In which case?
Lordship, serial number 187, Lordship, is this?
Huh?
187, Lordship, serial number.
186.
Uh,
186, sir.
I'm sorry, my lord. I'm sorry.
What do you say?
My lord, there is already a report that has been objected by the petitioner. If she accepts the earlier report, we are ready to lead evidence on the earlier reports. She herself has given consent for DNA test for earlier report. It is a part of record of the trial court. She objected for that report, denying the genuinity of the report. Then, by considering for the best evidence to give a substantial justice, the trial court has, family court has passed an order.
Please come. The wife is before this court agreed with the orders passed in I number 4, whereby the court had allowed an application filed by the husband under section 45 of the Evidence Act to prove his case by way of a DNA test. The parties are referred to as wife and husband. The MC number 584 of 2020 is filed by the respondent husband seeking divorce on the ground of adultery. It is his case that basing on the conversation between the wife and an unknown person, which was recorded and exhibited before the court as Exhibit P4, that clearly shows that the child the child.
Now, in this CD, she has admitted the extramarital relationship. Thereafter, she has undergone for
the child is not born in the wedlock, and because of the wedlock, and further, even before filing the case, she has accepted that she's having extramarital relationship. In fact, a test was conducted and which reveals that the petitioner, the respondent, is not the father of the child. But the same was denied by the wife. As such, the husband had come up with the instant application. The wife had filed her objections to the application, and the court, by order impugned, has allowed the same. While allowing the application, the court has observed that after hearing the phone conversation between the wife and the unknown person, and also both the wife and husband, as recorded in Exhibit P4 CD, the court is of the clear view that the wife had clearly admitted her extramarital sexual relationship with some other person. Hence, in those circumstances, the court has felt it just and necessary to order for a DNA test to find out the paternity of the child born to the wife. Otherwise, the court has also observed that it is highly difficult to adjudicate this issue. Otherwise, and the court felt that in the facts and circumstances, it is necessary to get the DNA test done. And counsel appearing for the wife submits that the son cannot, the child cannot be made to undergo this test. And even according to the husband, already earlier a test was done. It is submitted that just because the wife is speaking to an unknown person, that itself cannot be a basis for the husband to come up with this kind of application. And in the light of the settled law, such applications cannot be allowed. Land counsel preparing for the respondent husband submits that in fact, even before filing of all these cases, the wife had accepted and the child had undergone the DNA test. And as for the same, it revealed that the child for the petitioner, the husband is not the father. No, she's turning around and denying the same. And and this is the only mode through which you would be able to show that the wife is living in adultery. It is submitted that the court had rightly considered and granted, and no interference is called for. This court, having further counsels, produce the material. The MC is filed seeking divorce on the ground of cruelty, and he has already filed certain audio tapes before the court. And by listening to the said audio, not audio file, listening to the CD that's Exhibit P4, the court has come to the conclusion that, as per the same, the wife had admitted her extramarital relationship, particularly under the considering the fact that the submission of the case of the respondent, the husband, that already the earlier DNA test revealed that he is not the father of the child. It attains more significance, and in those circumstances, to put the best scientific evidence has to be in place. The court had rightly ordered the petition, and this court finds no reasons. Thank you.
Question number 187.
Lordship, I'm for the petitioner.
Ardhavji.
Just learn that
Appear for respondent, your lordship.
parties have settled the matter between themselves. So I may be permitted to withdraw. Lordship.
Yes, what do you say?
Lordship, I take instructions, your lordship. I don't have any instructions. I may be
They are
posted for
settled?
tomorrow, your lordship. It may be posted for tomorrow, your lordship. I take instructions, your lordship.
You get instructions.
Please, lordship. May be posted for tomorrow, your lordship.
I'll settle the matter to get clear instructions. Let's just matter tomorrow.
Please, lordship. Much obliged.
Question number 188. B. Ravindra. 188 B. Ravindra.
Petitioner, madam.
For respondent, madam.
My lord, impugned order dated 1st October 2022. madam.
1st
Here,
October.
Petitioner is the father, my lord. The respondents are the son and daughter of the petitioners.
Where is
Sought
Where is impugned order?
impugned order page number 14. my lord.
The respondents are hereby directed to pay interim maintenance of 10,000 each to the petitioner. Petitioner is the father.
Yes, my lord. Both the respondents are majors, aged about 27 and 23 at the time of petition.
Petitioners have filed the petition. Sons have filed against the father.
Father, my lord. Son and daughter.
125.
That has been modified by this honorable court, dated 12/3/2024, directed the petitioner to pay a sum of rupees 5,000 per month to only to the daughter and pay the entire arrears. my lord. We complied and we paid the entire amount.
Daughter is an unmarried daughter.
Daughter is unmarried.
Hmm.
Email is not there. Reply one short date.
How can the court grant to a major son maintenance?
On the ground that, my lord, they submitted some medical records. That, my lord, shows that he is suffering some health element. That is the reason, my lord, the trial court granted 10,000 rupees to each. Meanwhile,
What do you want?
1 week.
Why 1 week?
Short date, madam. Any short date.
Does this matter? on 29th. At the request of non-counsel for the respondent, no further time. Yes, 189.
189.
Petitioner, in this case, the main SPD MC number 75/23 is disposed of on 28/11/23.
28,
28/11/23.
23. It is submitted that the main MC itself is disposed of on 28/11/23. Nothing survives in consideration in this petition. Dismissed as infructuous. Yes, 190.
Bill number 190.
Connected. It was already connected with 10506, which is my petition. However, I
List
see that-
along with so and so.
105, I'll give.
Give the number. List along with so and
So
so.
they have not served the copy of petition to
Yeah.
me, though it was directed by this court that.
We'll see that day when it comes. List is martyr on 30th. Along with so and so. Yes, next.
Yes.
Of 24.
Lords, I appear for the petition in this case. I seek a pass over my seniors on this.
Yes, pass over.
192. Bill number 192. Damodar.
No representation for the petitioner. List is martyr tomorrow for dismissal. Counsel for the respondent is present.
Bill number 193.
In this case, my lord, I appear for the respondent. In the connected matter, I'm appearing for the petition. It's a maintenance petition. Impugn order is at page 16.
You are the petitioner in which matter?
And this, my lord,
Connected.
35 of 2021.
192. And 193.
193.
Yes, 193 only called.
Petitioner, my lord. Senior is out of station, my lord. 1 week's time may be granted, my lord.
The matters RPFCs of 2021 have to be cleared maximum within a week. So we can't adjourn the matters.
I need pass over, my lord. I'll take
Pass
instruction.
over.
Please.
You can come if court will look into.
Please, ma'am.
Your senior's presence is not necessary. Yes.
194. P. Anita. J. Shekhar Gowda.
No representation, dismissal day after tomorrow.
Bill number 195.
195, madam, I am a proxy counsel.
P.
I am
I appear for the
representing
appellant, my lords.
the counsel on record, my lord, is not in station. His daughter is not well. Therefore, my lord, he prays for.
My lords, I may. My lords, I request a date may be fixed, my lords, because if my lords could see the order sheet, every time they've been taking time, my lords.
No, it's the last chance, my lord, because therefore, my lord, he has.
No, the arrears are not cleared.
Somebody is not in, if a person, the advocate is not in town for 4 weeks, that can't be a ground for adjournment. He should make his alternative arrangements. You should ask his colleague, any of his colleague to represent. If he stays for 1 year in London,
it's-
will not grant that adjournment.
Not like that.
21 matter.
I can understand, my lord. I am told that regularly maintenance.
Let him make his alternative arrangements. We'll have this matter on 12th of August.
At least 18th
Great,
of.
my lords. Great, my lords.
The matter on 18th.
Please.
Finally, no further
Bless.
adjournment granted. Yes.
Please, my lords. Okay.
Bill.
Yes.
A submission, my lord. Serial number 107, my lord, for dismissed for non-prosecution. I've already taken the process in the last date of hearing only, my lord. I request.
First of all, don't come, don't represent the matters.
I apologize.
Again,
I apologize, my lord.
a red carpet welcome by posting in dismissal.
I
Again, no
I
representation.
apologize. I really apologize.
Which is that?
Serial number 107, my lord. I've already paid the process, my lord.
107. It is submitted that the needful is done. List at the service of notice. Yes. Call this number.
List number 2.
Plus there is typographical error as in the order, I think
Wait
4
for the
AM to
appellate, madam.
7 PM is.
In
what the-
operative portions, my lord.
Plus in
No, the
list
order
two
which
first
is-
Memo
matter.
for being spoken to, my lord.
1 minute. Let her call. View the file.
Point 1 minute.
1 minute. father is permitted to have the overnight custody of the child
On
on first
first
and third Saturdays between
4
PM, that is.
4 PM to 6 PM on Sundays, my lord. That is one. My lord, may I request
Between
for
4 PM on Saturday to
6 PM on
which
Sunday,
is-
my
Which
lord.
is right in the second point, my lord.
My lord,
Second
and
point
No,
says
no, no.
the father can
The
pick up.
first is father is permitted to have the overnight custody of the child on
First,
first and
third.
third
right.
Saturdays. First and third Saturdays. Then he can pick up the child at 4 PM on Saturday
Correct.
and drop him on
6 PM. But
That
my
is
lord, the
correct.
first point
But
is
however,
4
first
AM it
point-
shows and it's
That we
not.
will that will clarify.
And my lord, may I request, my lord,
Also,
now.
second and fourth,
No, in a, for being spoken to, no further requests, sir.
My lord, my lord,
Let's
the
one-
first
one-
and third
Only a
Saturdays, my lord.
typographical mistake that will be cleared.
My lord, first and third Saturdays, my lord. I'm a request for few on fifth Saturday because idly getting I'm twice in fifth Saturday when it comes to this year. And in next year only 4.
Can it be when I'm passing the order, all of you were there before
Please,
you
my
have passed order, and that is not the scope of our being spoken to. Please come. This court has passed an order on 3rd of July 2025, whereby this court had passed an order for visitation and also with regard to the maintenance. Now it is brought at in the order portion. In first condition number 1, it is mentioned as the father is permitted to have the overnight custody of the child on first and third Saturdays between 4 AM to 6 PM. Both the counsel submits that there is a typographical error in the order, and in fact, it was Saturday. The father was permitted to pick up at 4 PM on Saturday, and he has to drop the child back on at 6 PM. Sunday.
which is reflecting in point 2, my lord. That is correct. Point 2 is
But
correct.
when it comes to the first and third Saturdays, my lord, may I
The
request?
lordship has elaborated at point 2, which is correct. Point 1 has become 4 AM, that's it.
Then they like it is.
It was okay, I don't know, they have moved it, I'm not sure. Probably one other thing they want.
Then counsel for the then counsel the petitioner submits. Then counsel for the respondent submits. The order is very clear that at point number 2,
Correct.
the court had clarified that the father can pick up the child at 4 PM on Saturday and shall drop the child back at 6 PM on Sunday.
Which
In
is
that
being
view of the
exercised
matter,
also.
clause number 1 of the order is clarified. It shall be read as between Saturday 4 PM to Sunday 6 PM.
That is
Yes. And other things we can't. Yes, accordingly ordered.
Great.
Number 2, parted matter.
My lord, I am for appellant. My lord, the insurance company appeal does not survive now because I am already, after hearing both the sides, my lord, 50% is permitted to withdraw. They are on a driving license. My lord, their contention before the trial court is it is a fake one, but it
Where
is
is Mr. Ravi Samprati? Passover?
only quantum, my lord, now remains.
That's what he has to be here for whatever it is. Passover?
Tomorrow, my lord?
Yes, tomorrow.
Serial number 3, for orders matter. Wish to orders serial number 3. Come here.
Petitioner.
Rectification of office objections on IA number 1 of 25.
Lord, that copy I have served it on my learned friend.
Sir?
Yes.
Counsel
On
for
the
the
last day.
respondent. Counsel for the respondent. Because again, they're showing it. Counsel for the respondent is already, sir. Yes. Take that.
May I, my lord?
Let's look at the synopsis.
Please, may I also place this
please,
for your
yeah.
lordship? Please. Sorry.
Yes.
Lord, the
You're appearing for the wife or husband.
wife, wife's petition for,
We'll just look at the events, the synopsis.
please, my lord.
We'll look at the synopsis given.
Please,
by
my lord,
you.
I shall take
Please
it.
come to that.
Please, kindly take the synopsis that I have placed on the card. Your lordship's notice. Now, so far as the date of marriage and all that, there is no dispute about it. 31/12/2005. He files an MC petition and obtains an ex parte order during the pendency of decree during the COVID time. Hence, it came to be
set aside by this honorable court and remitted back. But thereafter, I have entered appearance and filed my counter also before the trial court. And thereafter, my lord, on 15/9/23, I have filed an IA in page 68 to 75 with annexures for interim maintenance for myself and minor son. Lord, then I have filed along with that itself the affidavit of my assets and liabilities, which also is part of the record in the annexure C series. Then I have placed on record his salary details which he was drawing, and also I have placed on record the under annexure D the investment of more than 4.1 crores that he had made even in the mutual funds investments, which is part of the record before the trial court also. I have placed on record even annexure E, my lord. If your lordships were to kindly see, that is the objections he files to this application. And he does not file his assets and liabilities. Thereafter, on direction, he files it on 5/12/23. There, my lord, he utters blatant lies, which I'll demonstrate to your lordships when I take your lordships through that particular document. He does not disclose about his true income at all. But the income tax return which he himself produces, it shows his annual income as of 2023 itself was 1.16 crores per annum. Lord, that your lordships would find it at I have placed it at F column, Lord, that I'll take your lordships to the relevant page also. And thereafter, the learned trial judge, and what he does is in the statement of objections, he misrepresents to the court that he has been paying 15,000 rupees. Apart from that, he has been incurring all other expenses, including the education of the child. And the learned family court goes by it and records it also that he has been paying according to him. And besides that amount, another sum of 30,000 was awarded by the family court by interim maintenance. I'm agreed before by that order. I'm before your lordships. I have placed on record, my lord, even the documents to show that even for the education expenses, the last year's admission fee for the child, for his transportation fee, nothing was paid, despite several email correspondences which I placed on record. That's he replies saying that 30,000 rupees is awarded by the family court. That's all. It includes everything: your maintenance, the education fee of the child, the maintenance of the apartment, the tax payable to the apartment, everything. Lord, this can't be an interpretation that can be awarded, made, my lord, and that's why I am before your lordships. Thereafter, my lord, I have placed on record even the documents evidencing that my father had paid the admission fee for the school for the child, transportation fee and everything for the whole year. Thereafter, even for this current year, for his academic year, he is now entered the BCom. For that also, he does not pay when I request him by several correspondences. Then, my lord, again, I had to trouble my father, who is in superannuation. He's 80 plus. And I had to trouble him, and again, he pays this money. Lord, I am before your lordships being aggrieved by the order passed by the learned judge under annexure G. This is the synopsis that I have placed on record. I'll take your lordships through the relevant pages.
1 minute. Let's
Please.
look at the synopsis.
Please.
Placed before by both the parties.
Please. And in fact, he was directed, if your lordships were to kindly recollect, he was directed to place on record the documents evidencing the education expenses that he paid to the son, and nothing is placed on record. That was a direction by your lordships on the last hearing day.
Very simple, Your Honor. And why the MC proceedings to be stayed?
Milord, my humble submission to your lordship is this. What happened was, once this order came to be passed, and
You're seeking enhancement of the maintenance.
Truly.
For that, why the MC proceedings to be stayed?
Milord, they would insist for the matter to go on day to day. My humble submission is, I have no objection if the matter has to go on, fine, fair enough. At the same time, Milord, he also needs to pay for the education of the son. Milord, I have a kindly.
1 minute. Please tell the court, any order of the court is violated.
Not with respect to this 13 to 24. Please.
No, not about whether it is an order passed by this court or order passed by the trial court. Is it?
Truly.
When once it is not so and you're seeking enhancement,
Please.
for that, why the MC proceedings needs to be stayed?
Milord, my humble submission to your lordship is this. I put a question to myself like this. Milord, here is the respondent who the father does not pay for the child's education for the day-to-day expenses of ourselves, and where the learned family court has heard. And we are expected to go on with the matter, even the expenses I am running about to arrange with my father for the funds. In such a situation, I am expected also to conduct the proceedings. It may be a little too harsh on the part of the respondent to insist upon going on with the trial. He also needs to compensate for the child's education. Ultimately, the purpose is that.
That I understand.
Please.
We have to independently adjudicate on that application. And that cannot be a ground to stall the MC proceedings. We can understand as any of the order that is passed by either the family court
Please.
or this court, he is not complying with, then the MC proceedings needs to be stalled.
Milord,
But not otherwise.
I follow, Milord. May I bring to your lordship is this. The learned family court, in the order itself, has committed even an order which is error apparent on the face of the record, which I'll point out to your lordships. Whereby, while the learned family court observes, he has been paying, according to him, 15,000 rupees. Apart from that, another 30,000 rupees would be fine for the
One
maintenance.
thing I want to make clear.
Please.
No, I'm hearing this matter, whether we conclude it or not today, but the stay granted by this court, staying the MC proceedings will have to be vacated.
Please, I shall ultimately.
Then please come. Where is impugned order? Impugned order. Let's see.
Yes, please. Kindly peruse Annexure G.
Page number.
I'll provide to you lordships. In page number 282, it commences.
Yes.
The relevant page commences from 283.
Yes.
This application is filed by the respondent under sections 24 and 26 of the Hindu Marriage Act and sought interim maintenance of 1 lakh per month and also medical expenses. She is the legally wedded wife of the petitioner and in wedlock. She gave birth to male child who is now aged 16 years. She is unemployed and depending on her parents. She is taking care of her son. She is not able to maintain herself and her son. She had major spine surgery in the year 2021 and her father had spent 6,61,050 for treatment. Further, her son had suffered dengue fever and her father paid 1,21,861 towards medical expenses. Petitioner has sought dissolution of marriage with an intention to harass and escape from marital obligations. She needs 1 lakh
From
rupees
which year they are staying separate? 17?
2017.
Yes.
The petitioner is paying meager maintenance of 15,000 per month. The said amount is not sufficient, hence requested to allow the application. The relationship is submitted. This is the petitioner's case. His objections. The respondent has filed the present application after a lapse of 4 years from the date of filing of the petition. Instead of conducting cross-examination, she has filed this application to prolong the case. The petitioner with his savings has purchased a flat jointly and respondent is living in the said flat with her son. Petitioner has been paying the entire education expenses of his son. The respondent, in order to harass him, has filed criminal misdemeanors 210 of 17 under the provisions of PWDB Act. The said petition was dismissed for non-prosecution. During the initial stages, this court has passed ex parte decree by dissolving the marriage. The respondent has preferred WP 8966 of 2021. She has also filed MFA 6713 of 21. The matter is remanded back to this court. The conduct of the respondent reveals that she is attempting to harass the petitioner. He is a private sector employee and he has to maintain his aged and ailing parents. He is regularly paying maintenance of 15,000 per month to the respondent. She is B graduate in instrumentation technology. She was gainfully employed as professor at Dayanand Sagar College of Engineering. She is interested only to extract money from the petitioner. She is healthy and capable to do work. With these contentions, he has requested to dismiss the application with cost. Heard both. The petitioner and the respondent have submitted the affidavit of assets and liabilities with documents. The petitioner is relied on the ruling reported in so and so. The points for consideration are whether the respondent is entitled to receive 1 lakh per month towards interim maintenance for the petitioner. What order? Partly in the affirmative is point number 1, answer, and point number 2 as per final order. The relationship is not in dispute. It is an undisputed fact that son of the parties is under care and custody of the respondent. It is an admitted fact that respondent is receiving 15,000 per month from the petitioner for maintenance of herself and her son. It is not in dispute that the respondent and her son are residing in a flat jointly purchased by the husband and wife. The respondent submitted that in the year 2021, she had major spine surgery and now she is unable to take up any job. According to her, the medical expenses and treatment charges were paid by her father. The respondent has further submitted that her son had suffered dengue fever and her father had met the hospital charges. It is clear that the petitioner and the respondent are engineers. Admittedly, the respondent is a homemaker. According to the respondent, the petitioner is working at Infineon Technologies as principal engineer, director, technical marketing and system architecture. She has submitted that the petitioner is getting salary of 56 lakhs.
I have seen the order.
Please. What I want to bring to your lordships is this. Kindly, if your lordships were to notice on.
Before we go into that, please tell the court. Now, what are the expenses according to you the husband is taking care of?
Now he is paying only 30,000 rupees as directed by the family court.
30,000. Never he taken care of the educational expenses.
No, he used to pay a little of it before. When I moved the application thereafter, the situation is, and whatever the difference were, my father used to make up.
She has to quantify that. What is the
Truly, kindly taking page number 326 in the paper that I placed. That is in the second volume, where the quantification is shown. What it would cost the breakup.
She says another volume is there.
Yes, second volume and also an application I have also filed that also. I'll take your also.
Page number
326.
Who stays? No, the wife along with the child, she stays.
I think your lordships have this.
Yes,
this is the expenditure incurred all along and expected expenditure in future with no provision for cost escalation. Groceries, dairy products, vegetables, breakup of each heading is provided. One is for groceries, 16,000, then domestic help, 4,000, then the medical expenses, 5,000 rupees, which includes for the consultation for both the mother and the son. Then the apartment maintenance is 2,800, then now it is 5,000 and odd. Now broadband connection of 1,200, cable 700
I've seen
rupees.
that. Total is 45,000.
No, it is 45,200. Now kindly come to page 322, 322 and 323. There your lordships would notice. I think your lordships have that. This I'm on page 322, internal page 5 of the affidavit. For this Kensri School and College for the admission fee of the child for the whole year, 53,000 rupees was the tuition fee. Kindly 12,000 rupees was the tuition fee. Kindly turn to the next page. Towards the books, towards bag and towards transportation.
39,000.
39,000 there. And that this plus another.
That is inclusive of everything.
Everything.
No, here you are showing 53,000 plus 39,000.
Please.
That itself is coming around 92,000.
Please.
And again another 45,000 you are showing as expenses.
May I submit? That is why this application, which I took your lordships through this. Hence, I made this application for enhancement before the trial court because of the changes in circumstances, because of the academic year when it's commenced. When the order was passed, the child was in the earlier previous academic year. This, by the time this application came to be filed, by which time there has been correspondence when the academic year was about to start for the child. Hence, I request him to pay for these fees because the fee structure is provided by the school. He does not pay. Hence,
he is in the same school.
He was in the same school. Now he has gone to become. Now I'll submit your lordship. Then he was in the Kensri school. Then the admission fee for him to be paid for the next academic year was 53,000. That's which came.
So, according to you, you have filed this IA when?
Well, I filed this on 28/5/2024.
So,
28/5/24.
So till 2024, father was taking care of the expenses.
No, expenses. Food, my lord, 15,000 he was paying. School expenses, some extent he was paying, and my father used to manage, which was small ones. To that extent, I don't have complaint because I have not said so.
So no,
Please.
till 2024,
Please,
till the application is filed.
Yes, ma'am.
He's taking care of the educational
Not
expenses.
there, no, itself.
23.
20.
So educational expenses are taken care. That's one. Number two, what was he towards the other things than the education?
That your lordship, he claims himself in the statement of objections, he says, I'll take your lordship to that.
No. I'm asking your
Yes,
case.
my lord, the other expenses was more than 40,000 rupees. Apart from the 15,000, he himself used to incur for the family, household, and tuition fee and etc. of the child. That's how he would. The reason is this.
What was he giving according to
I'll submit. May I submit? May I submit? So far as apart from the 15,000 rupees, for the main being all that, I was not driven to such a corner where I was not able to manage at all. Now here is a situation when entire thing totally comes to this 30,000 rupees, which can't be managed with such kind of situations which arose. Hence, my lord, I had to trouble the kind. While on this, my lord, I also would like to bring to your lordship's notice, kindly peruse page 288 for a moment in the imperial order.
Yes.
Ma'am, this, my lord, this is what somewhere in the fifth line, this is what it reads. As admitted by the petitioner, he is getting net salary of 4,42,308 per month. So the petitioner is capable to pay reasonable maintenance to the respondent. Considering all the documents, it appears that apart from 15,000 per month, the petitioner is capable and able to pay maintenance of 30,000 per month to the respondent and their son. Lord, this is what the learned family court's observation. But however, while passing the final order, the order is passed only to the extent of 30,000 rupees. This is so far as even this 45,000, if this 15,000 also had been granted, still it would not be sufficient. Lord, I need to bring your lordships with respect to take your lordships to the assessment liabilities also.
We'll continue after, continuation after lunch.
Much.
Lordship, one submission, my lord. Serial number 169, my lord. The matter has been passed over a week to be given, my lord. Serial number 169, list number.
For Passover, it will be called. That time you have to come. You can't make a mention now.
Please.
Yes.
Serial number 46. Dismissal. Kindly one week time granted. Serial number 46. 46. List
41 in which list? 41 in which list?
First list.
Why you are not
46.
there?
46. Serial number 46.
Why you are not there? Order is passed already in the morning. You were not present on the last occasion today morning, and you come in the now when the matter is listed for at least dismissal. That time you should ensure your presence before the court.
Connected matter is at 12:08. The notice is served to the respondent.
Very unfortunate. What is the number?
Serial number 46.
46. Then what about the process?
Connected.
Each day.
177.
Take that.
First list, my lord. The MC matter has been disposed, my lord.
Yes. Give that. 177. It's all double work for the court. Every time this is happening, every day. It is submitted that the MC number 134 of 2021 is disposed of on 27/2/2024. Hence, a memo is filed. Seeking to withdraw memo, straight down record, and dismissed as withdrawn. Yes.
Lordship,
Serial number
list number 2, serial number 5. I filed an application for recall that has not been put up in the file today, my lord.
It's already adjourned.
List 2, serial number 5, my lord.
It's already adjourned.
Not called yet, my lord. My learned friend is also online.
Yes, my lord. I appear for the petitioner. I believe my learned friend has filed an application, my lord. I have not been served with a copy. So
I've served copies by way of
So it
registered
is
post on
coming
our
up for
request.
file is coming up for non-compliance of office objections.
My lord,
In this
my lord,
matter, I
the
have filed
office,
Which is the number?
5, my lord, 5.
5 is coming up for
Yes, my lord.
non-compliance of office
It's for
objections.
it's for non-compliance, but I have filed an application for recall of the previous orders.
So we'll see, first of all, what is that non-compliance, then we can grant you the time and ask the registry to place that the IO also before the court. Yes.
Serial number 64, my lordship.
Hmm.
List 1, my lordship. Correct address of the respondent need to be furnished, my lordship.
Where were you when the
Lordship,
matter is
I held up in
called?
Code 20, my lordship.
So why should we recall? How many times you will not be present? I'm telling the advocates, this is like accommodation has
apologies,
become
my lordship.
like, you can't go on so leniently, you can't take
No,
it.
no, my lordship, held up in court at 20 months.
What about the other day when the matter is listed for dismissal? That day you are held up in which court?
Sincere apology, my lordship.
You should feel sorry for this. 64, a week's time default order.
My lord, list to serial number 6, my lord. It has been posted for awaiting service of notice, my lord.
Who are this R2 and R3?
They are the minors, my lord. Child.
Then they will be represented by R1.
Please, my lord.
Then why this is, please wait, let him come.
Please.
My lord, serial number 4, next, my lord, second list, my lord.
4
In
and the
fact,
respondent, it has been dismissed for non-prosecution and not paying the
my lord,
compliance.
I have already complied to observe, my
We
lord.
will see then, we will see. They are also there after lunch, we'll see. Yes. Correct. In that one judgment is relied on, that copy you can have. I think this is the one. No, in that there is one judgment here. State of Ireland, there is Shamim, not. It's not this one. There is a promotional software. There is. We'll see when it comes.
You know.
ತರ್ಸ್ಕೊಂಡಿದ್ದೀನಿ ಅದನ್ನೇ ರೆಫರ್ ಮಾಡಿಲ್ಲ
ನೋಡಿ ಇದು ನಿಮ್ಗೆ
ಫಾರ್ಮ್ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್ ಬೇರೆ ಕೇಸಲ್ಲಿ
Result for orders something
ಸರ್
175. Result for orders
ಎಷ್ಟು ಜನಕ್ಕೆ ಆನ್ಸರ್ ಮಾಡಲಿಲ್ಲ ನೀವು 175 ಅಂತೀರಾ 171 175 ಏನಾಯ್ತು ರಿಸರ್ವ್ ನಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತು ಯಾವ್ದು ಯಾವ್ದು ಸರ್ ನಿಮ್ದ್ರಲ್ಲ ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ನನ್ನೇನು ಯಾವ್ದು ಕೇಳಿಲ್ಲ ಇನ್ನೊಂದು ಯಾವ್ದೋ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಅದ್ರಲ್ಲಿ ರಿಸರ್ವ್ಡ್ ಅಲ್ಲಿ ಏನ್ ಜಡ್ಮೆಂಟ್ ಕೇಳಿದ್ರು
175 ಅದು ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ಅಲ್ಲ 175 ಪಾಸ್ ಓವರ್ ಆಗಿರೋದು ಪಾಸ್ ಓವರ್ ಅದು ರಿಸರ್ವ್ಡ್ ಅಂತೀರಿ
ಆರ್ಡರ್ ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೀನಿ
ಮಾಡ್ತಿದೆ ಸರ್ ಮಧ್ಯಾಹ್ನ ಐ ವಿಲ್ ಕಾಲ್ 2:30 ಕಾಲ್ ಔಟ್ ನೀವು ಅದ್ರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಪ್ರಸನ್ನ ವಿಆರ್ ಹಾ ಸರ್ ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ
ಅಷ್ಟೇ ಅಷ್ಟೇ
171
ಓಕೆ
ಒಂದ್ ನಿಮಿಷ ಅಲ್ಲ ಇದು ಯಾರು ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ತಾರೆ ಅಂತ
Why mention now?
Lords, the matter is rendered infructuous, my lords, only to make that.
Chain number 22, my lord.
In second list?
Yes. Against interim order that is.
MC is disposed of? MC is disposed of?
125, yes. That matter.
It is submitted to the main the petition is filed against the interim order asked in C miscellaneous number. The main petition itself is disposed of and nothing survives for consideration in this petition. Accordingly dismissed as infructuous. Yes.
My lord, serial number 165 in the first list, my lords, the main MC is disposed of, petition is infructuous.
Why there is no representation in the morning?
My apologies, my lords, I was logged in the other court, I was not keeping well, my lords.
165. Dismissed as submitted the main look at it MC or is disposed of and it's become infructuous. Yes, next.
Wait, 193, there's a possibility of settlement between the parties, my lord.
It's already over 193.
No, my lord, 193.
190?
3, my lord. The parties, both husband and wife, my lord, there's a chance of
No, this list is completed. 190?
3, my lord. Mediation, lordship may refer for mediation, my lord. There's a chance of settlement. 193.
Well, arrangement says that he wanted to
Settle the matter.
Bangalore Mediation Center. When?
Next week, any day.
On 30th of July.
Please. Published.
Yes, for the list.
Interim order granted, my earlier.
Interim order granted earlier.
Yes, please.
List number 2, serial number 3.
Yes.
Yeah, Anand from.
Now, I was, could I request your lordship to Could I request your lordship to peruse the document that I have placed on the card? He was not paying for the medical expenses. That's what in the Lord, that is what I have even claimed in the application also before the London Family Court. In fact, I had written to him by emails. He can appreciate the situation. He deserts, goes away. I had suffered I had suffered certain injuries in
that I've seen.
2015 injury. In 2021,
some 6 lakhs and odd is what
6 lakhs and odd. Then, and my son added to it, falls ill. He suffers. He contracts dengue, for which I bring to his notice. He says probably treatment is not correct. You say the document.
According to you, medical expenses not paid, educational expenses not paid. And you require 45,000 for monthly expenses. He's paying 30,000.
30,000 rupees, and the 45,000 rupees, as I showed to your lordships, the particular annexure. My humble submission, I have added to it the future educational expenses for the son also being not paid. I request him by emails. Kindly, I just want to show it to your lordships the attitude and this conduct of this respondent. Kindly take the email that I have placed on the card, which he says, which your lordships would find it in the second volume.
We will not be going into all that.
Please,
because now the issue is whether the amount that is granted by the family court is right or
Truly.
not, or it needs to be enhanced or not.
Truly.
We'll hear this in
No, truly, it's only I make my endeavor only to bring to your lordship's notice, because he says it includes everything. It can't happen. He can't have the cake and eat it.
No, because when you're seeking for maintenance, court grants any amount.
Please.
You should always be like inclusive of everything. You should ask for everything. It
Fine.
cannot be, court will not say for this much, this is inclusive.
Truly, my lord,
exclusive.
truly, my lord, the human difficulty that one would face day to day, kindly appreciate. The child is a school-going child. Each year, academic year, he gets the.
That's what, that's what you should ask. When it comes to the educational expenses of the child, what is the contribution of the father? That
Nothing. He doesn't. That is the reason why I had to make the application.
Yes.
Your lordship would notice, he pleads as though that he doesn't have much income and all this. 4.1 crores he has deposited in the mutual funds and he has got such huge investment. What we are pleading is only for our basic necessities, nothing more. Kindly, this is what the conduct is. Kindly consider.
Yes.
My Lord,
Yes.
I would first make submissions. The child's educational expenditure, kindly note down, my Lord. I am ready and willing to bear all the expenditure, and I was bearing all the till 13th
Let's forget about bus. We will say
please, my Lord,
that you are
up to
you are
13th
complete,
of 13th of February 2024. I was paying everything. I will put it on affidavit. If my learned friend files anything, it amounts to perjury. But I have taken the full responsibility of the child. There is no second opinion about it. It was a mistake on February 2024 onwards. It was not paid. In fact, I instructed him, and he agreed today afternoon also. It may be recorded in your lordship's order. That portion,
That is
on
one aspect, yes.
whatever that my petitioner has paid, that I will ready to reimburse whatever the school fees as per the receipts. I will ready to, and also whatever the expenditure for the child, my Lord, will bear all that one. Yes. That undertaking I may be recorded. Kindly see the conduct of the petitioner. 2017, admittedly they separated. Admittedly they separated. He was driven out from the matrimonial home by assaulting him, tried to strangulate him, having confronted with the material that you had a illicit relationship with XYZ. You are doing all things wrong. Rather, she go to the this domestic violence court, sought for 2 crores and 1 lakh per month.
I see. Now it's dismissed for default now.
Please, madam. Irrespective of all that, I continue to maintain everything by paying 15,000, already paying even before going to the domestic court. Apart from purchase jointly, my Lord. No, that itself is more than 50,000. And what we are paying is 30,000 as per the orders of this trial court. But this is more than enough. I will undertake that whatever the as I submitted, that amount will be borne in respect of child's education.
What is the age of the boy?
Maybe 17 or 18.
He just turned last month 18.
18. But nevertheless, my Lord, I will take the, and while going for a higher course, now I am told that he is studying in BCom. If he perceive further education, let me have a discussion, and I should also have a participation in that, because he should not be sent somewhere else. I am ready to bear all that expenditure, whatever he studies. That to that extent it can be recorded. So far as, my Lord, from 2017, I continue to pay. 2019, the MC case was filed. It is not an ex parte order. My learned friend should see the order sheet. What has happened? How many opportunities was given by the court? Several, and it was recorded in the order sheet. If my Lord wants, I will place it on record. There was no alternative for the court. They passed an order on the basis of my evidence and material on record and granted a decree of divorce. They filed initially a writ petition before this honorable court against that order, obtained an ex parte order, and later when we contested saying that how the writ is maintainable, then they filed an MFA. When the MFA was pending within a short time, I conceded. Saying that all right, let her have a fair opportunity. That was disposed in 2022.
This is pending on the file of which court?
Which one, my MFA?
Second additional family court.
Second additional family.
Which year is 2018?
2019.
2019.
2022, the division bench of this honorable court remanded the matter on a concession extra. I did not argue the matter. I said simply, let her have an opportunity. It also mentioned that it should be expeditiously disposed of. Later, my Lord, they did not cooperate. Continues to harass the petitioner. And 2023, they filed this application. When it comes to cross-examination of the petition, they filed this petition and obtained an order of extension. All this has happened when it's come to their bottleneck that the evidence should go on before the trial court. She is able to live with whatever that maintenance for more than 5 years initially. How can all of a sudden she says that no, I want 1 lakh rupees? But this shows the conduct, and she wants to have a luxury of life. But it is my hard-earned money. I am having 2 aged parents. They are 90 plus. I am taking care of them. My another brother, he is living in US. Even today, I have to take care of my parents, and they are ailing. Their medical expenditure. Apart from that, my Lord, the basic needs has been met by the petitioner here, I mean respondent hearing. Insofar as the medical injury the petitioner has sustained, it is not at my instance. I don't know what she has committed. It is her own making. And say that there is a dislocation and I have to spend so much. And trial court, what now trial court said in the impugned order is, there is no material placed before the court to show that she has spent this 6 lakhs rupees. And it will be determined at the time of the trial. That's what the trial court did not refuse it actually.
Yes, then we'll go to that order again.
Please, ma'am.
Where is that mentioned?
Annexure G, page.
This particular portion.
Please, Miller. Page 284 starts. Your lordship will go to page 288. Para 13. The respondent has also claimed medical expenses and treatment charges from the petitioner. It is worth expenses by the respondent to be considered at the time of final disposal of the case. Accordingly, I answered partly affirmative. The order is very reasonable. It is not that I have conceded anything. I also stated that my home tax salary was about 4,50,000 rupees. There is no dispute over that. I'm working as a software engineer. But she wants money. She don't want to live with me. Under these circumstances, can it be possible to live together? And kindly see the time at which the applications were filed, seeking this.
No, your salary is 4,50,000.
50,000 approximately.
So why not we grant 50,000 as?
Well, I'm already with accommodation.
No accommodation, but 30,000.
Please.
Look at the breakup. What is given?
Well, that breakup in an exaggerated,
See,
exaggerated.
And you tell the court how it is.
Please, please.
We'll see this
Page
page number
177.
326 he was referring to.
Please. Please, ma'am.
Where is that?
Page 326.
Second one.
In the
Of the main petition.
main petition, I mean, my learned friend
It is the
said,
main petition only. It's
There
something
are two
because it had to be stitched, it was heavy.
There are 2 volumes.
In order
please,
to
ma'am, I was
hand
given
it-
only one volume.
No, I have provided both sets. No,
Yeah.
I have, no,
Sorry,
I don't.
sorry, my
I'm
apologies.
sorry. I would never do that.
326.
Where is that? Your
326.
expenses?
Not in page number 326.
326. Yes. Please come.
Please.
Please come to that.
Groceries, 16 something that groceries is required even in our
According to
family
you-
itself. It will not come to
Let's
that
say,
one.
According to you, how much is reasonable?
But now as it is, we are paying 30,000 rupees. Though it may not be recorded as my submission, my lord, of course, maybe another 5,000-6,000 your lordship can enhance it. It is not for a luxury life, my lord. And
Actually,
sons can,
no.
I'm sorry, ma'am.
When I've looked at this,
Please.
having seen so many of these expenditure statements, what I felt is like she gave a very reasonable expenditure. Generally, it is not like so in any other matter.
No.
If you look at it, no, forget about this 16,000, domestic health 4,000, medical expenses 5,000, apartment maintenance 2,800.
3,500. My lord, your lordships know that government of Karnataka, for a small family, it is virtually exempted the electricity
I have
payment.
placed the electricity bill. I'm sorry.
I'm sorry to my learned friend. I don't know. It should.
No, I
It
have
shows
placed it. I'll
that
take your
exorbitant spending.
Let's see.
Electricity bill put on. Put in. Number 2.
One more submission to my lord is, my lord, though my learned friend can make any sort of allegations, whatever the savings or any property left by me, I am not going to marry another one. I will not have another child. This child will inherit everything. And the aged parent, they don't want anything. They are in their fag end of their life. And brother, younger brother, he is well settled in America, both the doctors, husband and wife. Nothing goes to anywhere. Even if my learned friend want to put 4 crores, 5 crores. All right. Do you mean to say that I have to spend exorbitantly? And this man, my client, my lord, sorry to say, is a very simple man. Though he's earning 4.5 lakhs. He don't even have a chauffeur driven car. He himself drives. Sometimes you don't drive also. And this lady, having committed a blunder and having all that, I don't want to mention again and again, that she don't deserve any enhancement according to me, but I don't want to say anything. And file applications and applications.
Now, there are already specific directions to dispose of all 2019 matters.
Please.
MCs. No, the court will do it by December 15th. It
Please,
will be
please,
disposed of.
please, my lord.
Yes.
And so far as Ayush education is concerned,
That I'll record.
I must also have a say in the matter in his future endeavor in going for any higher education and other stuff. And one more thing, your lordship ought to say, let him be subjected to a counseling that may also help us. Apart from arguing this,
File an appropriate petition before the court.
it is there already.
Let persuade the court to pass orders on that. Instead of this court,
Please.
without any, adjudicating on the application when it's already pending,
Please.
may not be right to pass any order.
The whole conduct of the petitioner is she wants money, that's all. My lord, I'm sorry to say this one. In fact, out of record, I'm mentioning, I did request at the other side, not my learned friend, to other counsels who were there, try to establish a relation with the son and father so that it may improve the relations of the mother. They did not choose to do that at any point of time. Though my learned friend said, I have mediated, no doubt I have mediated. I tried to sort the things out. They were bent upon to have a huge sum from. I leave it to my lords.
Yes, what is
May I,
the
my lord?
response?
Lord, kindly peruse while in the second paper book, page 332 in the first paragraph, 332.
Yes.
Since my learned friend expressed it out, just only to bring to your lordship's notice, in page 332.
Yes.
Your lordship would notice that is the power consumption bill of 2000. Now, I'm sure your lordship would
consider
truly,
that.
lord,
No,
truly,
let's,
now
anything you want to, please.
please,
submit
my lord,
and
so far as making a statement assassinating my character, my lord, I take a serious exception to it. Please, that is what I'm submitting.
That also will not be considered.
Truly, my lord, that is subject to still trial.
That's not be considered. Now, only point is, as far as the educational expenses are concerned, he is ready to bear for the child. Though he is now 18, even after that also, he is ready. That undertaking I'll record. Then coming to the maintenance, I will be enhancing it by another 10,000. And with regard to the medical expenses, court has rightly held that during the course of trial, because now a timeline is going to be fixed.
Please,
the court is going to
based on record the documents before the family court about the medical expenses incurred.
No, it will be considered
Please, kindly bear with me. Let me make my submissions clear so that the documents have been placed on record before the family court. Any document that is placed before this honorable court in this petition are part of record before the family court. First submission. Nextly, my lord, the respondent has not challenged that order passed on 13/2/2024. Why I'm bringing to lordship's notice this. Kindly turn to page 288. That is the order passed by the learned family judge. On page 288, what she observes is, since he admitted before that, in his statement of objections, kindly notice what he states. He admits what he has been paying according to him. He claims that he's been paying 40,000. Apart from that, another 15,000 rupees he is ready to pay. That's how we are paying it. I'll take your lordships through that. Annexure E for a moment. Only that particular line, I'll just point to
paragraph number 13, above 3 lines.
Please, my lord, I am on page 175. This is a statement of objections which he filed to my IA before the family court. Wherein this is what he says. May I request the lordship to peruse for a moment?
Yes.
In page 175. This is annexure E.
Yes.
May somewhere at the bottom.
Yes.
Paragraph 4. The petitioner was maintaining all the expenses of the home, including household expenditure and the personal needs of the respondent, and was bearing all the expenditure to educate his son operated before the court. This is what he gives a breakup. And he says that he will also bear that educational expenses of 80,000 rupees per year. This is what he made the statement of objections before the family court, whereby he was the family court was made to be carried away by this. Kindly now turn to page 288.
Yes.
What the learned judge observes is besides that 15,000 maintenance of 30,000 per month to the respondent and their son, whereby which would come to 45,000 rupees. And he is not before this court challenging this order at all. Well, that amount at least cannot even be reduced. Firstly, my submission. Well, I have made out a case in my humble submission to your lordships with the documents to show that how much his educational expenses which is costing me plus maintenance. Well, I have received notices which is part of the record from the Apartment Owners Association to pay the maintenance charges. He pays maintenance charge for an adjacent apartment which he owns, he and his brother own. He doesn't pay for this. Well, how we should run with this 30,000 rupees that is sought to be paid? This is where I am before your lordships now. Can you consider and grant this?
Please come. Agreed with the order dated. Agreed with the order passed in I number 1 in MC number 304 of 2019 dated 13 February 2024. The wife is before this court seeking enhancement of the compensation. By order impugned, the court had granted an amount of rupees 30,000 per month to the wife and her son as interim maintenance from the date of the application till the disposal of the case. Learned counsel for the petitioner submits that the court, while passing the order, has considered the fact that apart from rupees 15,000 per month, according to the husband, what he is paying, is capable and able to pay maintenance of 30,000 per month to the wife and the son. It is submitted that comes to rupees 45,000. It is further submitted that the medical needs of the wife as well as the son were not taken care of by the husband, as he has failed to take care of the needs of the wife and the son. They're facing with a lot of financial difficulties. The expenditure is 45,200, and also stated that 53,000 is a college fees, and other expenses of the child are about 39,000. Learned counsel for the petitioner further submits that the court has failed to consider the case of the wife, and further, though he is not the court had failed to consider the case of the wife, particularly with regard to the medical expenditure, where she had to borrow huge money from her father to pay for the operation and also other medical necessities of the child. It is submitted that when the husband is earning 4 lakhs and odd per month, and there cannot be any difficulty to pay an amount of rupees 1 lakh as claimed by the wife. It is submitted that the husband has completely neglected to maintain the wife and the child. Next paragraph. It is also submitted that she has been continuously sending him emails and also asking him to pay the amounts, and the husband has not reacted on to any of the mails. Which shows the conduct of the husband. Next part. The senior counsel appearing for the husband submits that the house in which the is jointly purchased, the entire amount is paid by the husband. That
which I dispute. I'm sorry. Huh? Which I dispute. Please.
And it is submitted that that apartment will fetch an amount of rupees 50,000 as rent. Now the court had granted an amount of rupees 30,000. Just because he's earning 4 lakh and all, that doesn't mean that the husband is ready to take care of the educational expenses of the child, provided in the future any plans with regard to the colleges and other things, the father should have a say. It is submitted that even the father is ready to pay the educational expenses, repay the educational expenses which are already paid by the mother from 2024, 2025.
The bill, madam.
Huh?
With the bill.
No, they have been provided also.
All right, you can send
That it is submitted that is the same or provided by the wife. The receipts that she has already paid, make the payments, the same will be reimbursed, the same will be repaid by the husband. It is submitted that already that is the amount that is granted by the court is exorbitant and no further enhancement is required. He submits that the proceedings were initiated in the year 2019 and from there on the wife had the wife is delaying the matter, and in fact when the wife is seeking enhancement of the compensation, she has sought for the stay of all further proceedings. She is making all efforts to see that the proceedings are not concluded. The proceedings are not concluded. Further, it is submitted that in the domestic violence case, she sought for 2 crores compensation, and that came to be dismissed for default, and the same is not restored. In fact, initially an amount of rupees 10,000 is granted as maintenance. Then senior counsel submits that the petition is not maintainable, and the no enhancement is required, and the petition needs to be dismissed. Next paragraph. Having heard the counsels on either side, concern material on record. There is no dispute about the income of the husband, nor about the relationship. The first aspect is with regard to the educational expenses, future educational expenses, and to repay what has already been paid by the wife, provided she comes up with the receipts to show that she paid that she paid the said amounts. As far as this aspect is concerned, no orders required to be passed. The wife shall submit the same before the trial court, the bills, and accordingly the trial court shall consider looking at the same. The husband shall pay the amount. Then coming to the future medical expenses, as rightly argued by the learned senior counsel, the father shall also be made part of this the deliberation with regard to how and where the son has to pursue his future future career, as it is the father who is going to bear the expenses. Then coming to the maintenance, this court has perused the expenditure that's placed before the court. That is an amount of rupees 45,200, and also the other is with regard to the educational expenses of the child. This court is not inclined to go into that aspect, as already the father has undertaken before this court. It is submitted that the father is ready to take care of the expenses of the child. Then the expenses are 45,200 as placed before the court. As rightly argued by the learned counsel for the petitioner, when the court at paragraph number 12 of the order observes that apart from rupees 15,000 per month, the father is capable and able to pay maintenance of 30,000 per month to the respondent and other son. That means it comes to an amount of rupees 45,000. This particular order, this court deems it appropriate to modify the order passed by the family court, enhancing the maintenance from 30,000 to 45,000.
Why 45,000? The word is very clear. For both respondent and son. But son expenditure, I am bearing it entirety. Therefore, your lordship has to consider only for the wife, because I am paying everything for the son.
I'm sorry, my lord.
My learned friend cannot interpret in a different manner.
No, my lord, with your lordship's leave.
Kindly see the lord.
Expenditure of the son will not be only education, some other expenses. That also needs to be borne. He undertook only for medical.
That is also included 2,000 per month.
No, he didn't say so. He said only with respect to educational expenses. Now he can't misinterpret it.
No, for all groceries and all expenses, sons is also included.
Please.
So what it should be deducted from 45,000? Ayush pocket money, Ayush tuition fees, project stationery. This has to be, so it comes
Wait a
to, this is 45.
But
It
that
falls-
expenses is already spent. That I have
Spent
also.
expenses, we are not on that. We
Please.
are on the future expenses.
Please.
8,000.
I have provided the bills also, the receipts for having paid.
8,000 itself is about the 9,000. 9,000 expenses are of the sun in this 45,200.
Please.
So if you deduct this 9,000, it comes to 30,000.
Lord, he can't take advantage of such a situation. Lord, he is not even in
So
appeal.
what has happened, you see?
Please.
Now that particular portion of the order, now if he is not taking care of the entire expenses of the child, it is a different aspect. Now he's going to take care of the entire educational expenses. It may run into like double the amount what is already you're spending. Now you will reimburse. No, you said 1 lakh.
Please.
This is 53,000 plus 39,000.
Please.
It's coming to around 92, 93,000. Whatever you have spent is going to repay that. That is one aspect. And only on this 1 lakh, if he is going to spend for the son, how much it will be?
I'll take your losses to that. Lord, it's not that I'm trying to snatch anything. Lord, what we are asking is only for a meager amount for our own sustenance. Lord, when he draws nearly 10 lakhs per month.
Make it 40,000, modify to
Please,
40,000.
please. Great.
Lord, maybe on the lighter side.
Expenses are there.
Yes,
And future
expenses.
expenses are going to be, if you say that let's not forget, let's forget about it because it's already.
Lord, in which case let
No,
him
one
pay
minute.
maintenance
2000
separately of the
no,
apartment.
2018. No, I mean, now he has become 18 years old.
Truly.
So if you don't think about that educational expenses, who will pay that?
Lord, obviously, Lord, he has to pay because I am a homemaker.
That's why he's paying.
No, Lord, my submission to Lordship is, Lord, sustenance, because the apartment, Lord, as of today, the maintenance is coming to 5,000 and not per month for the maintenance itself, for the apartment. Mainly make it at least 45, Lord, which the trial court did it.
There may be direction to dispose of the matter in a time framework, my lord. And they
This
should
is
not
MC
take any
of-
adjournment. They should
MC
not.
of 2019, already the specific directions are issued to the family courts to dispose, family courts at Bangalore to dispose of the matters.
Expeditiously, madam.
2019, matters till 2019 by December 15th. As this matter is of the year 2019, the family court shall dispose it of by December 15th. No unnecessary adjournments no unnecessary adjournments shall be granted.
Please.
Pardon, Lord, that at least that apartment maintenance separately he could pay, Lord.
What is that?
Apartment maintenance, Lord, that also comes.
So that is what is included in your expenditure.
Lord, that was, please, he can.
In
pay
fact,
it.
even this
Lord,
amount also excessive.
Please, he can wait.
No, if I have to calculate, excluding what is your son's expenditure, it is coming to 33,000.
Lord,
But I said 40.
Anyway, Lord, I'll leave it.
Yes.
Please.
Number 4.
So and so. But the counsel, the petitioner has paid DCF on 16/7/2025. Later than the date. Court has asked you to pay within a week.
My lord.
That is on 36. You paid it on?
My lord, the file was not reached to the,
On 16/7. From 36 to 16/7, where the file will be?
my lord, the file had not reached the scrutiny branch, my lord. I made 4 attempts, my lord, to complete the office objection, my lord. Later I complied the office objection, my
Yes,
lord.
it is submitted that
One more submission, my lord.
this court had ordered it at 36/2025. Had directed to pay has directed to comply with the office objections within a week, or else the petition stand dismissed. As per the office note, he has paid the DCF on 16/7/2025. Land council. Then where is the application to set aside that to recall that order?
That is not filed, not served to me.
Since office objections have been complied, my lord, I did not file up.
Can't be like that, Mr. Counsel. I have already passed a default order. You giving all these reasons, you should file an IA.
I'll file, my
Yes,
2 days ultimatum.
list after 2 weeks to file the necessary application.
2 days ultimatum.
List after 2 weeks to file the necessary application.
My lord, in the meantime, my lord, I have sent the demand draft, my lord, as a direct with some code. This is written, my lord. The
What is the
respondent,
demand draft for how much
at
amount?
every month 3,000 I need to pay, my lord. That I have sent,
What
my
is
lord.
the, why, how can she?
What he, look, this is the same case where your lordship had moved a memo. He has taken a DD in the name of the respondent, whereas it had to be taken in the name of the registry. But he has never given it to me, in fact.
My lord, on
Never. This is
submission,
the
on
first
submission,
time
my
that
lord.
he is
Before,
even
before,
mentioning.
before moving the matter before Honorable Court, my lord, the memo was filed before coordinate bench, my lord. The other bench directed me to purchase the DD of 25% in the name of the petitioner. Then I'll take up the matter. Accordingly, I took the DD, my lord. Later,
Take it.
It could have been handed over in the
Petitioner,
family court.
the petitioner has.
because 2
has
months
taken-
later, sent me the only copy, my lord. I'm sorry, my lord. Before lordship, I opened the cover, my lord, with the permission of the court. Anyway, I'll do the needful, my lord.
Yes, next.
Serial number 5. Radha
The
J.
respondent in this matter.
My lord, I appear for the petitioner. My lord, I've complied with all the office objection. The only objection is, my lord, that they're asking me to file the photocopies of the IAS. My lord, all the office copies have been filed. In fact, my learned friend who has appeared has no objection to it, my lord.
No, let's see what is the council submission to office objections. Let's see. Original photocopies of IAS to be filed.
Yes, my lord. I have already, they're all the office copies, my lord. And my learned friend also has no objection to it.
It is not your learned friend's objection. There is a procedure, is it not? What to be filed? And what is a man, whether it should be a certified copy, it should be a, your office copy.
They're all my office copies. They're all true copies, my lord. My lord, I'll make an application for dispensation of.
That's what has to be done. For
All
that,
right,
why
my lord.
all this, why council submission, what the council will submit, and how the court will agree when there is a procedure to be followed. If you're not
All right,
following,
my lord. I'll make an application for dispensation of
office
production.
objections or sustained, and necessary application, if any, shall be filed within a week, or else the petition shall stand dismissed. Next,
We undertake the minors. Respondent number 2 and 3 is a children of respondent number 1.
You will be representing them.
Yes, madam.
Yes, R2 and R3 are the minors, represented by R1 the mother. Mother is already represented by an advocate. Yes, what is this matter?
We want some time, madam.
Interim order is granted.
Senior is held up in another court. 1 week time may be granted.
It has been complied, my lord.
Land counsel for the petition submits that the interim order passed by this court is complied with. Then counsel for the respondent seeks time, lists the matter on 29th. If the interim order granted by this court is not complied with, the interim order granted by this court shall stand vacated without further reference to the court.
Much obliged.
Rupesh Kumar as for petitioner.
For the first respondent.
Who is R2?
My lord, he is the defendant, second respondent in the MC, my lord. And he is not supporting my case, my lord, he is the respondent. I am the proposed respondent, my lord, in this case. I have challenged the IA passed for pleading.
You know, why notice to R2 be dispensed with?
Lord, it is a divorce petition filed by the wife as against the second respondent, my lord. And the wife has filed an impleading application to implead me by stating that the respondent husband has had an affair with me.
No, but she is a party. About whatever is the outcome, she is not, she is not affected by that. No, whoever it is at R2.
R2 is the husband of R1. I filed a petition for divorce on the grounds of cruelty and adultery.
That's what I'm saying. For this petition, husband's presence is not required.
He wants to.
Not required.
How can you decide that? He's a party.
However, he has not filed any objections to that application, my lord.
That can't be. Let it be. We'll not dispense with that. You argue, you are for the wife.
I am for the wife.
See.
But the application, my lord, is filed to implead the present petitioner by stating that the husband has an affair with me, my lord. And along with this application.
What is the submission is? That's a photos one.
Yes, my lord.
What is the submission is? You have placed certain photos. Basing on the photos, the court has ordered the implead petition. And according to the council, that whoever is appearing in that photos is not the impleading party.
23 reasons of the trial court.
Read.
Admittedly, the petitioner wife has filed this petition seeking dissolution of marriage against the respondent on the grounds of adultery and cruelty. It is also an admitted fact that the respondent husband herein filed separate matrimonial case against the petitioner registered in MC number so and so under section 9 for restoration of conjugal rights. Based on the memo filed by the respondent herein, both the cases were clubbed together for the purpose of common trial and disposal. Not at this stage of proceedings, when the case is set down for petitioner side evidence, the petitioner has come up with these applications by stating that the respondent is leading adulterous life with the proposed respondent, and for this reason he has subjected her with mental cruelty. Admittedly, the burden is on the petitioner, that is on me, to prove her case and prove the allegations made against the respondent. The petitioner in this petition has stated that the proper and effective adjudication of the case, the proposed respondent is a just and necessary party, without which she is unable to prove her case. Even this fact was seriously denied and disputed by the proposed respondent. Only thing is, there were two applications filed. One is the present application under Order 1 Rule 10. The other one is an application under Order 7 Rule 14(3) for production of certain documents. Both the applications were taken up together and a common order is passed here. This is what he has assailed. In fact, there's a division bench judgment of this court, which I may please be permitted to place on record.
What is the ratio? On what ratio?
The ratio is whether the adulterer or the adulteress is a.
It's a settled law. He is saying here,
please.
Relying on certain photographs, you said that so and so person is so and so and impleaded. According to him, that's not the lady.
In fact, my humble submission is the trial court has not appreciated the evidence. It has only said the burden is on me to prove.
That's why the court has not granted any interim order. The last occasion when he argued before this court.
Please.
My lord, kindly see the page number 24, my lord.
Yes, at the stage of an Order 1 Rule 10.
I agree, my
First of all, you have to come. No, her whole petition will go unless and until that lady is a party to it when she's seeking divorce on the ground.
Why unnecessarily I have to be impleaded, my lord? And I have to go through the litigation, my lord, which I'm not concerned with.
No, here the court's finding is, unfortunately, what to do? That's all.
My lord, I agree, my lord. Because of the photographs, my lord, submitted by the respondent here, the court has considered that photographs and application.
The court only recorded that.
My lord, at least let them produce before this court, my lord, some documents to show that I am in relationship with the husband.
What are the documents that are filed before the court by you?
Certain photographs, video recording, and certain audio clippings are produced. It is a matter of trial.
Certain things, no, it's not a matter of trial. You are producing the photograph showing that this is a lady with whom the husband is having the relation, and you want her to be impleaded to this MC.
Please.
So where are those photographs which are filed before the court? Do you have?
Right now, I don't
will take up day after tomorrow. Please produce it. What is the connection? Basic prima facie. No, you show the photographs of A. You want to implead B.
And
how can it be?
Those persons in the photographs also be impleaded, my lord. In that case, my lord.
Please.
There are prima facie evidence, my lord.
Kindly see my petition filed before the trial court.
Page number.
Page number 37.
Yes.
This is para 33.
Please read.
The petitioner has knowledge and proof to establish that the respondent has had affairs with many women, particularly so and so. In fact, even
Rajgopal is also there.
I am not taking names.
Vanita Rajgopal and Champaka
is a widow and mother of a child. The respondent and so and so were caught red-handed by the petitioner, and she had warned them both. In fact, after the petitioner left her matrimonial home, so and so started to live with the respondent and also helps him conduct the health club activities. This is the specific allegation that I have made in the petition. This I'll have to prove with the with some evidence to be placed before the trial court. It is a matter of appreciation of evidence, which only the trial court can go into. In these circumstances, I sought implement of the petitioner herein.
No, that I can understand. Looking at para 33 of this, you take 5-6 names. You take 5-6 names.
Please, whatever proof I have, for that reason, I have sought the implement. And the trial court holds that the burden is on me to prove all these allegations.
I'll pass orders. I'll pass orders. Reserve. No reserve.
Lord, I have denied those statements, my lord, already.
I may be permitted to place my statement of objections to the petition, please.
Then counsel has placed for the court statement of objections for the response.
Here for the respondent wife.
Delay of 125 days.
Please.
Condone the delay.
Please, that.
I number 1 of 22 is filed to condone the delay of 125 days. For the reasons stated, delay is condoned. Have you served the copy on the?
Copy is now in the afternoon it has been served.
And counsel the respondent that already he has received the copy of the petition.
That's one request before my lords. The order is dated 26/3/2022, my lords, granting maintenance to wife and daughter to the tune of 35,000 per month, my lords. Till date, nothing has been paid. My only request is that my learned friend may submit.
Let me submit.
One
if he is going on merits, let me submit. I was placed ex parte. I am based out of Bombay.
No conditional order is passed in this.
No condition.
No conditional order. No order is passed.
No, IA number 2 is first is pending.
I have no interim order is operating.
Then no, you should have filed your AP.
That is one difficulty, my lords, that he is from Mumbai as what my learned friend has submitted. The warrant never goes. The only FLW is issued. No other coercive steps issued by the court.
What is husband doing?
My lord, petitioner is an engineer. He's working at Reliance. He's based out of Bombay. The first respondent wife is also an engineer. Your lordship would kindly see there the judgment of the trial court. No material has been placed to show that the second respondent child is mentally challenged. No material has been placed to show that she needs continuous treatment. And
what is your income?
My income, as on today, my lord, take home is 1,40,000. That is my instruction.
What is the wife's income?
She has not disclosed. No affidavit.
I'm unemployed. That is what I wanted to
No, my lord. She is a graduate engineer, a BE. And
How much is granted by the court?
My lord, 10,000 for the wife. Maintenance. 10,000. 10,000 for the daughter. Then another 10,000 for the medical for the daughter. And again 5,000. I have not entered appearance. I have not filed my say at all before the trial court. They have not even complied with the judgment of the Honorable Supreme Court. No affidavit of assets or liabilities.
After service of notice, why you didn't appear?
My lord, there was no service of. My lord, this was instituted during the COVID time, peak of COVID. It was sent by RPAD. Intimation delivered. No intimation was delivered at that time. We do not know what the postal department is doing.
Consider all the aspects on the merits of it.
But let it be remanded back. Whatever amount till then, I'll keep paying in the.
We have to. What is the amount? Like how
the
much?
The amount is 35,000 as of now per month. That is clear.
That's what I'm saying is I'm not asking you to pay 35,000. Some reasonable amount from the date of order till now You pay that, then on that we will remand it.
Yes, Mary.
Just like that, we'll not remand.
What is the amount your lordship would feel?
20,000.
I will seek instructions, my lord,
Please
your
get
lordship.
Minutes. In the
This is
meantime,
smarter.
may I make one request, minutes? If that is the case, minutes, if both the parties file their affidavit of assets and liability before this court,
Will not decide all that.
please.
This is an order passed by the court. What is the date of order?
Please, minutes. The order is
26th of March 2022, my lord.
26th of March 2022, where the husband was at ex parte. And the court granted maintenance of an amount of rupees 35,000.
35,000 to both.
35,000. Agreed thereby the husband is before this court. Then counsel the petitioner submits that he was not served with any notice. As such, he could not appear. Land counsel appearing to the respondent submits that the husband has not paid any amount after the order passed by the court. There is no dispute about the fact that the husband is earning 1,40,000 and the wife had not filed a statement of assets and liabilities before the family court.
Minutes.
However,
Minutes,
to
I have
balance the
it.
interest of both the parties, if the petitioner is ready to pay an amount of rupees 20,000 from the date of petition, from the, yes.
Most grateful.
Number 9, PS Nagaraj.
And number notice has to go.
Notice has to go.
256 days.
Well,
256 days delay notice,
256.
notice is responded.
Well, he's already been arrested. That is why.
He's already arrested.
He's arrested.
Anyhow, let him be there in the meantime.
The question is, he's a second wife. First husband's case, he has two daughters. One daughter is with this petitioner, and she's a mentally disordered girl.
How much is the amount granted?
20,000 rupees is awarded.
So,
No,
the amount you have paid?
I am not paid because I am maintaining her second daughter is with me, is a mentally disordered girl. First, this is the second marriage.
What were you doing without filing a petition?
My lord, there was a delay because it was an ex parte order made without notice. I engaged the advocate. He, without notice, retired from the case.
Where did you say all these things that you are taking care of the mentally retarded daughter of?
Yes, I have stated, my lord. In para. So truly, the petition respondent here is the married lady, and her first
Paragraph number?
Para number 2, page 4. Her first name is T.C. Yemalata, and she is the native of Talkad village, Tinasipur Taluk, Mysore district. And in the name of Yemalata, she married with one Mahesh, son of Rangegowda of Talkad village. With their marital life, one T.M. Vidya and T.M. Kanwa was born under date 23/2/2000 guntas of wetland in survey number 696 of Talkad village, and also one house property number 6/233 measuring 18 by 36 feet was given to her. Therefore, her husband T.R. Mahesh and his father Rangegowda both had executed a settlement deed 20th/2/2004 in her favor, in favor of Hemalata, that is respondent herein, and her two daughters by name Kumari T.M. Vidya and Kumari Kavana. And also they have agreed to perform the marriage of their two daughters. The copy of the said settlement deed is submitted herewith at Annexure A, registered page 31 only.
How much is granted?
20,000 is granted. Married, I really more than 20,000 rupees are spending. Her second daughter, she is a mentally disordered. She is.
Your income?
Pardon me?
What is your income?
No, my income is 40,414.
Why you are spending? What is that expenditure of 20,000? How you are spending?
No, my lady, she is with me and I'm maintaining her medical expense and all that.
Fine. Anything before this court to show?
No, I will bring her.
Not bring her. Did you find anything to show that towards her medical expenses? You
The
are
medical
paying?
expenses have not paid, settlement deed is made, and marriage perform invitation is.
These are all that we are not going to. What is that to show that you are paying towards that child?
Married or livelihood and all that is required, married.
20,000.
No, married minimum.
Unless you show something, will not grant stay.
No, because it is true, because if she is taken, that girl is.
Think about specifically you are asserting something, but that the document is required. You come up with the document list day after tomorrow at the request of land council to petitioner. Yes, next.
Notice, ma'am.
Notice.
Notice regarding the.
Notice to the respondent.
My lords, in IA number 2, the trial court, my lords, City Civil and JMFC, Arkal Good, had granted 6,000 rupees towards maintenance, my lords, interim maintenance. And subsequently, in IA number 4, my lords, it has stayed its own order, my lords.
Let's see.
Yes, my lords.
Where is improved order?
My lords, IA number 2 was for section 125(1), my lords, for maintenance which we had given. And the IA number 4 was on section 125(4), my lords. They have made baseless allegations, my lords.
Let's see. Where is improved order?
Page number 34, ma'am. Actually.
Come to paragraph number 10. Give that CRP. Read paragraph number 10.
My lords, the respondent filed the above IA order for stop the payment of interim payment of interim maintenance passed under section 125(1) of CRPC on the ground that the petitioner number 1 is his legally wedded wife since the date of marriage. She was demanding for lavish life and she was not ready to living in the poor family of the respondent. Frequently, she was visiting to her parents' house and demanding to make separate house. When the respondent was working in SESCOM as a temporary employee, he took the petitioners to Murnadu, wherein the petitioner number 1 gave birth to petitioner number 2 and 3. He had launched a complaint in to Madikeri police. At that time, the parents of the petitioner number 1 came to Panchayat and was held by considering the words of the elders and the parents of the petitioner number 1 that the respondent.
Notice will see.
My lords.
Take out notice will see. The petitioner.
Your Lordship,
Any
would like to
execution
make a
is filed?
submission here.
Yes, the notice, emergent notice to the.
Your Lordship, I would like to make submission here. The contention that they have taken in section 125 clause 4 is about the alleged adultery in this case, Your Lordship. Wherein in this case, they have only led the photographs to prove adultery in this case, Your Lordship, which is not sufficient to prove that.
We'll see. At other side.
Number 12.
Yes.
Yes, Naveen Kumar. So, E for capital respondent.
But the petitioner is the husband before the trial court minutes. But the challenging the order dated 2/12/2024 annexure A minutes. But before the trial court, the main petition was filed by the respondent seeking under section 12 of the.
What is the amount granted?
Milad, this is not the amount, Milad.
6
Rule 17. 6 Rule 17 application was filed. 6 Rule 17 application was filed.
Section you filed.
Amendment petition.
Where it come to that order?
Milad, at page number 17 application was filed.
Section you filed.
Amendment petition.
Where it come to that order?
Milad, at page number annexure A, Milad, page number 10.
Which year is the MC filed?
2023, my lord.
Seeking?
Seeking section
Divorce on
12,
the ground.
1 subclass E for the registration of the marriage was registered at the sub-register office. That particular
Cruelty,
document
my lord.
should be decreed. Anta, right?
Come to your IA on order 6 from 17, page number.
Well, that is at page number 15, my lord, 15 and 16 of the order.
Let's read your application so that the facts will.
My lord, their respondent is the husband.
To add section 12 in the heading of the petition. To add after the words the null and void in the heading of the petition for divorce.
My lord, first the wife has filed petition under section 12, my lord. Later on, amendment was sought to incorporate section 13 clause 1 IA, my lord, based on cruelty. And the husband has filed RCR petition, my lord. In that, wife has filed counterclaim seeking divorce, my lord. And in this, wife is seeking divorce based on the grounds of nullity as well as cruelty, my lord. That's the reason we have filed 6 Rule 17. However, the application is allowed, my lord. Evidence is not yet commenced, my lord.
Lord, that is the only reason the trial court has found out.
Impugned order is
Before
at
the
page
trial
number
court,
16.
the evidence was not commenced.
Where is that?
Impugned order is at page number 16. my lord.
Page number, annexure A
16.
at page number 16, my lord.
It starts from 15.
Order is at page number 16, my lords. Lord, on the same day, the order was passed before the trial court. On the same day, I have appeared before the court and filed NOC wakalat, my lords. Even in my not consideration of my even single point of objections
In
for
your
the IA,
see,
please, my lords.
as observed by the court, what is the prejudice caused to you now? You have your defense.
Yes, my lords.
Hmm.
We have won our
You can
defense, my
submit
lords.
everything. No prejudice would be caused to you.
Lord, after 1.5 years also, they have not leaded the evidence only because is the reason is that section detailed objections before the trial court claiming that the section 12 was filed at the time of filing of the MC case, and coming that only reason is that the court was considered, even my objections was not considered. Pass the orders, only reason is that evidence was not commenced.
Do is, whatever your objections are, will consider and will affirm this order.
Lord, and
My
with
lord,
regard to
there
that,
is-
one
there
more
itself,
submission,
my
my
lord.
lords.
It should be.
My lords.
You should say what is the prejudice to you. You tell that the court will try to understand what it is.
Lord, my only submission is,
Apart
6
from
Rule
saying-
17 application was filed by the respondent claiming that some amendment is on the main prayer and also section 12 and section 13, my lords. Lord, once the petition is claiming that section 12 is nullity and nullity of the marriage or divorce of the marriage, my lords. And moreover, section
So the
6,
prayer
section,
is-
that,
My
yes,
lord.
my lords.
My lord, I have.
Not removed, that is
No, my
not
lord.
deleted, that is only add, my lord.
So
No, my
whether
lord.
the court has to decree it as nullity or
Please.
No, my lord.
the ground of cruelty.
No, my lord. Alternatively, I sought for seeking divorce for itself, my lord. Grounds are, I am claiming in the divorce petition, I have taken the grounds of nullity as well, my lord, and as well as the cruelty. That is the reason I have inserted to,
Ultimately, what is the prayer you are seeking?
my lord,
Ultimately, what is the prayer? No,
Divorce,
by
my
way
lord.
of this amendment.
seeking divorce, my lord.
No nullity.
No, my lord.
Under section 12. Under
My
section
lord,
12,
kindly
they are
see the
claiming.
application, my lord.
No, court should have passed some reasoned order.
Or in the RCR also a claim for counterclaim, my lord. More or less, the allegations are based on cruelty and nullity as
This
well.
order, the court is not able to understand what is that you want, what is that the court has granted.
My lord, I sought for seeking amendment to incorporate section
Basically,
13
it
clause
was-
1.
You wanted it on the ground of nullity.
Please, my lord. Nullity and also as well as cruelty as well, my lord. Because courts can consider both, my lord. I'll place it on record some citations also into that effect, my lord. In alternatively, court can grant divorce seeking the prayer for nullity as well as the cruelty, my lord. Section 12 and 13 clause 1 IA. That is the reason I incorporate section
So
13.
finally, what is this now by way of this amendment? Or what is the effect of this amendment?
Lord, I'm seeking prayer. Para number 19, my lords.
Yes.
May I read, my lord? In my opinion, there can be no bar in filing a joint petition under section 12 and 13 of the Act, claiming relief in alternative. The Honorable Bombay High Court in the case of so and so has been pleased to entertain a petition filed under section 12 clause 1IA and 13 clause 1A of the Act, wherein the prayer was made by the husband seeking divorce on the ground of cruelty, as also prayer for degree of nullity on the ground of non-consummation of marriage owing to impotency of wife. The Honorable High Court in the said case was pleased to hold as under the following order, my lord. However, both can be filed, my lord. Section 12 and section 13 clause 1IA.
Lord, the leave was not granted, my lord. The petition was dismissed.
What is that? What leave was not granted?
Lord, in the particular said judgment, my lords.
What leave was not granted?
Lord, in the particular said judgment, my lords. With related to that, I will submit, my lord. I will submit, my lord. I will get some other judgments, my lords. Lord, and one more submission, my lords.
No, one more. It is all the submissions at once. Yes. When do you want?
By next week, my lords.
It's a matter on 31st.
Kindly date may be fixed, my lords.
31st.
In meantime, I request kindly stay of the.
No.
No, my lord.
First of all, I should be convinced. I'm
Lord,
not
moreover,
convinced now.
and one more submission, lords. When 6 rules are
To quash the order dated 2/4/25 passed in IA number 2 of criminal miscellaneous.
Where is the order?
My lords, Annexure A, page number 17, my lords.
$30,000 is granted.
Yes, my lords.
What
Plus
is
two.
what is the income of the husband?
Lords, it's about 1 lakh, my lords.
Then?
But he has some other expenses and even aged parents here. Medical expenses
You
of
have
50,000.
70,000 to spend to the
No,
other
my lords,
expenses.
before the court order, before the court's order, he has voluntarily paying towards the respondent as maintenance of rupees 5,000. And
What she will do with 5,000?
lords, but then the quantum of
No,
maintenance.
we can't grant an interim order in this. Because 1 lakh you're getting, 30,000 court has granted. What is the difficulty?
Because he has aged parents. He has to take care
Then
of them.
you have a child also to take care.
This quantum may be decreased, my lords.
30, pay 20,000. The court had granted 10,000 maintenance and 20,000 educational expenses. When counsel the petition submits that the husband is not in a position per month and the arrears also at 20,000 within 8 weeks, or else the stay granted by this court stands vacated. Take out hand summons on the counsel appearing to the respondent before the trial court and shall file a memo by 4th. The memo is not filed by 4th. The stay granted by this court stands vacated.
2021, my lordship. My
No.
lordship, the petitioner is suffering from diseases, TB and lung infections, my lordship. He is suffering from the diseases, my lordship.
What is the material before the court?
My lordship, the respondent wife filed a divorce petition, my lordship.
Not about it. You are seeking on medical grounds. Where is the material?
I will produce, my lordship.
This is matter after a week, not after a week. List on 6th August. Yes.
Number 15.
Lord, petitioner is the husband, my lords. There are 4 parallel proceedings going on, my lord. Now, my lords, the husband and the wife, my lord, are trying to settle the dispute, my lord. Here, an interim maintenance has been passed. Parallelly, a domestic violence order has been passed. There also maintenance is passed. Parallelly, a maintenance case was filed. In that also, order has been passed. Meanwhile, in CP petition was filed for transfer. In that case, also an order was passed, my lord. Whenever the wife comes to court, you have to pay her the cost, my lord. Hence, now, my lord, talks are going on, my lord, and seek for 4 weeks' time, my lord. This is the interim order which has been filed, my lord. Challenged, my lord.
Any interim order here?
My lord, here no order. Fresh matter, my lord. Preliminary here.
Notice to the respondent. petition shall take out hand summons
My
in
lord, sir,
council.
if notice is issued, settlement talks will get disturbed, my lord. They do not know that we have challenged their order, my lord, because now settlement they are trying out, my lord. Hence 4 weeks time, my
They will not, they will never know.
lord.
They will never know.
Because if settlement happens, then we will not pursue this petition itself. We will withdraw the petition. That is why, my lord. In case we notice goes, my lord, there we will be talking to them and here from here notice will be issued, my lord.
We'll invite them to the high court. Here you can settle.
4 weeks time, my lord.
It's coming up for the first time.
Yes, my lord.
Why memo is moved for this?
No, we did not move the memo, my lord. It came
You have moved
automatic.
the memo.
Automatic.
First of council was there.
This is the matter when?
Next week, my lord. It's maybe
This is the matter on 13th of August.
obliged, my lord.
Till number 17. Ms. Patil.
For the petitioner, my lords, this is the wife's petition where she had filed for the divorce and it came to be dismissed.
1 of 25 is filed for dispensation of the production of the certified copy original. What is this original or certified copy?
Original or certificate copies.
You know, they should seek for what dispensation they want. Either one they should ask. The dispensation, the production of the certified copy of the order. Same, the IA is allowed dispense with for the present. Yes.
My lords, this is the wife's petition where she had filed the divorce petition and it came to be dismissed. Parallelly, she filed criminal miscellaneous under section 125 and it is allowed, my lords. She had filed it in 2012. After 10 years, in 2022, it came to be allowed, saying that he has to pay monthly maintenance of 10,000 from the date of the filing of the petition. So the total arrears was 15 lakhs, my lords. He did not make any payment. So she filed the execution proceedings before the first additional trial court, my lords. Later, he's actually paying the he's making the payment only bit by bit, my lords. Only if there is a hearing once in a 2 or 3 months, he's making the payments. So we have sought for the direction to to make the payment. My lords, are to expediently dispose the filing also, my lords.
That's a different aspect. Expeditiously disposing something is different. Give that. What is that prayer? To forthwith pay the admitted balance arrears of maintenance of rupees so and so in compliance with the order dated 29/7/2022.
My lords, in 2022, we have filed the execution proceedings.
Can't be done, please come. The prayer, the writ petition is filed, seeking the following prayer. Then counsel for the petition submits that in spite of an order passed for the court, the respondent husband is not complying with the same and he has not paid the maintenance. Hence, they have come up with this writ petition, seeking a direction to the respondents to forthwith pay the admitted balance arrears of maintenance of rupees 8,10,000. 10,000. The court heard the counsel for the petitioner. The writ petition has prayed for. The prayer that is sought for in the writ petition cannot be granted.
My lord,
And
short
for
date may
such-
be given, my lords.
For such relief, a writ petition cannot be filed, dismissed.
So number 18 adjourned. 19.
There are judgments,
Leaving
my
it
lords.
open.
Short date may be given, my lord. Senior may
It open,
appear before.
leaving it open to the party to avail the appropriate remedy. Yes.
19. Shivramu is chief of petitioner. Chandranath R. Gowle.
My lord, I appear for the petitioner. So then previously we got the memo for calculation and they've given a total of whereas medical reasons are PCOD and chronic back pain. In the first case, the wife has deserted the husband in 2021, my lord.
So why are we going into all that?
Because they have given a memo of calculation. So in this,
First of all, there are two petitions here. What is the amount that is granted by the court?
my lord, 20,000 is what has been.
Which number?
Page number 34. Page number 34, my lords. Para 23.
23.
May I read, my lords?
My lord, there is no
Please
evidence
read the
given.
order. Please read the order. Come to paragraph number 14.
One.
Come to 15, not 14, not necessary.
The respondent has deposed before the court as RW and got marked Exhibit 1 to 10 documents. The respondent has relied upon the receipt of jewelry purchased by him at the time of their marriage and educational qualification documents of the petitioner and treatment being given to his mother. So the respondent got marked CD in which the video recording of return of jewelries of petitioner to the father of petitioner is available. The learned advocate for respondent played the said CD in an open court during this argument. The learned advocate for petitioner cross-examined the respondent, suggesting that the respondent has deserted the petitioner without valid reasons on April 2021, when the petitioner requested him to allow her to live with her father. It is.
Yes.
It is further suggested that the petitioner made sufficient efforts to return to matrimonial home after 2021. But the respondent denied the entry of petitioner into the house. It is further suggested that the respondent has not made any arrangements for the maintenance of the petitioner in spite of having sufficient income from rent. My lord, this is what we are challenging, that there has been no proof that has been given for that there is a so-and-so date at Sri Narasimha Swami Temple, Mysore. The marriage of the petitioner and the respondent
So where is the discussion with regard to the income of the husband?
My lords, in fact, he stated that he is MBA graduate, my lords. Now he is saying that no, I studied only.
No, whatever it is, there should be something. What's the income?
My lords, we have produced the residential, immovable properties, which is.
My lord, none of the exhibits the
What is that?
My lords, from exhibit P. Sorry, my lords. My lords, in page number 31, my lords.
Receipt regarding purchase of ring. Marriage
Sale,
photographs.
my lords, exhibit P8 sale deed, my lords. Exhibit P8 is sale deed.
No, P18 to 21 are photographs.
No, my lords. Page number 36, my lords.
Looking at it.
Exhibit P8 sale deed, my lords. Exhibit P9 certified copies of sale deed and certificates of.
What is the extent of land? What is this property?
My lords,
My
we
lord,
will
they've
produce the
given
document. We will produce the said documents, my lords.
They have given a list of 10 properties which.
This is smarter. On 11th August.
Cell number
At the request
20,
of London Council, the respondent. Yes.
cell number
Please,
20 adjourned, 21. Abu Bakr Shafi, petitioner. Pradeep Nayak.
I have 1/25 for additional documents. What are these additional documents?
My lord, the impugned order is this. The
You are for the respondent or
respondent husband.
the petitioner?
Petitioner was here earlier. He is there.
Yes.
Here for the petitioner, my lord.
Hmm.
In this case, I filed an IA, my lord. Your lordship may kindly see blastoma, cancer of the eye. So trial court has order. Your lordship may kindly see the order of the trial court. Order of the trial court at page number. At page number 30, my lord.
30.
Yeah, 30. The petition filed under section 125 of the CRPC is partly allowed. Accordingly, the respondent is directed to pay a sum of rupees 15,000 per month to the petitioner number 2, the child, towards her maintenance from today till the age of attainment of her majority or till completion of her education, whichever is later. Further, the respondent shall incur 60% of the educational and medical expenses of the petitioner number 2, subject to production of original bills, receipts by the petitioner number 1 from the concerned
You are
institution.
appearing for the wife?
Lord,
You are appearing for the wife?
I am appearing for the wife.
You want enhancement of this amount? You have come up for enhancement.
Now, my lord, my prayer is, 1 second. Because
the maintenance for the wife rejected. Maintenance for the child is last paragraph, Lord. At the end, the prayer of the petitioner number 1, that is wife, for the maintenance was rejected. I am challenging.
Only you're on that.
Yes, on that. That is my prayer, Your Lordship may kindly see my prayer. That is, set aside the rejection of maintenance to the first petitioner. The question is, this honorable court ordered to pay the 60% of the whatever the medical expenses incurred to him to pay the, but he has not paid, and now what he is claiming, whatever the insurance for
No.
Can this court pass that kind of an order in this RPFC?
Lord, Your Lordship, the observation made by the trial court, Your Lordship, at para number 18, para number 18, page number 29, at line number, Lord, 11th line at page number 29. Further, the evidence on record shows that the respondent has the facility of reimbursement, respondent husband has the facility of reimbursement of medical expenses in his company. Therefore, it will not cause any additional burden on the respondent. Therefore, I hold that the respondent is not entitled for reduction of interim maintenance amount ordered. This court wide order so and so. So, my lord, now what is my humble submission is that, my lord, he has got also family insurance from his company, and I too have whatever the insurance. Totally, my insurance policy amount goes to the child, and I am also suffering with the thyroid, lot of problems. I do not get anything, and from my salary it goes, and also my ailing parents. For them also, I am whatever the 96,000 salary, everything goes to medical expenses, and the insurance, whatever my insurance from the group insurance policy, 5 lakhs, it goes entirely for that. That's why my humble submission is, from his insurance policy, let him pay 60%, and from my insurance policy, let me pay 40%. That my IA, Your Lordship may kindly see, IA filed on 15th.
You are not agreed to.
Your Lordship, recently I filed. What I mean in my application, that is, for the reasons set forth in the accompanied affidavit, the petitioner submit and pray that this honorable court may be pleased to restrain the respondent from seeking benefit from the medical insurance claim for which the first petitioner pays the premium, and the respondent is liable to pay.
All that this court cannot grant. This court can't grant.
But let him pay, my lord.
That's what. If he is not paying, you have a you can
Execution petition is
Yeah,
pending before
I have filed entire documents.
Execution
Entire
petition is
documents.
pending.
Let us not go into all. No, the only issue is why the court has not granted maintenance to you. Please come to that reasoning.
Yes, maintenance. Your Lordship may kindly see
Where is the discussion?
from para number 13 onwards.
Please.
12 also. The salary of the petitioner is discussed in the para number 12, 25.
Yeah, that is admitted because he is also
What is your
earning.
salary?
Yeah,
What is your salary?
his salary 1,50,000. My salary is 96,000.
Hmm.
1 second, madam. I'll correctly say.
And how much maintenance you wanted?
My lord, maintenance, 1 second, my lord.
20,000.
20,000. 20,000 for me, and
The court has granted how much to the daughter?
daughter 15,000.
15,000 per month.
15,000.
So then why you are entitled for maintenance from the husband?
For that, my lord, I am entitled. Your Lordship may kindly say, I have furnished so many compilation of citations that even though I am employed as a wife, it is already before your Lordship.
They are not here. Yes.
Memo the documents, memo citations. My lord. There are several compilation of my citation, my lord.
You can straight away come to a particular judgment. This is first is Rajneesh versus Neha.
My lord.
Citation number 1 is Rajneesh versus Neha.
Yes.
Which paragraph in that?
It is missing in my file, my lord. Second. Petition there. It is in the petition itself, my lord.
That's
I'm
what
searching.
I can
Sorry,
see
my
that.
lord. Petition itself. At page number 127 onwards, my lord.
Yes.
Citation
Which
number 1.
paragraph in Rajneesh versus Neha?
Citation number 1, my lord.
Yes.
That is Rajneesh versus Neha and others. So some income. The courts have held that if the wife is earning, it cannot operate as a bar from being awarded maintenance by the husband. The courts have provided guidance on this issue in the following judgments. 63. In Shailaja and another versus Kobanna, this court held that merely because the wife is capable of earning, it would not be a sufficient ground to reduce the maintenance awarded by the family court. The court has to determine whether the income of the wife is sufficient to enable her to maintain herself in accordance with the lifestyle of her husband in the matrimonial home. Sustenance does not mean and cannot be allowed to mean mere survival. Because here, my lord, whatever the salary comes to me, it goes entirely apart from the insurance policy. Entire salary goes for my daughter's that is cancer, eye cancer, retinoblastoma, eye cancer. So lakhs together it goes. And again, I am suffering with the thyroid and so many other diseases. So for that I am spending. And again, my parents also, the aged parents, nothing is remaining in my salary. Everything goes to hospital only, apart from the insurance. And my lord, second one, Sunita Kachua and others versus Anil Kachua.
Page number.
Same, that is continuing, my lord.
Yes, yes.
156 only. In the wife had a postgraduate degree and was employed as a teacher in Jabalpur. The husband raised a contention that since the wife had sufficient income, she would not require financial assistance from the husband. The Supreme Court repelled this contention and Sunita Kachwa held that neither the mere potential to earn nor the actual earning of the wife, howsoever meager, is sufficient to deny the claim of maintenance. An able-bodied husband must be presumed to be capable of earning sufficient money to maintain his wife and children and cannot contend that he is not in a position to earn sufficiently to maintain his family as held by the Delhi High Court in Chandra Prakash Bojraj versus Rani Chandra Prakash. The onus is on the husband to establish with the necessary material that there are sufficient grounds to show that he is unable to maintain the family and discharge his legal obligations. These are the citations, madam. And the same thing I furnished at citation number 2 in page number 175. That is of Silage. Already I read or all the citations. I separately I furnished it annexed to the petition, my lord. So, relying on these judgments, my lord, I am entitled for
maintenance because whatever I earn, it goes to hospital only. Nothing remains for me. And now, my lord, 60% whatever he has to give, hospital only. Nothing remains for me. And now, my lord, 60% whatever he has to give, that also he is not paying. He says whatever also he is not paying. He says whatever from the insurance company comes, you manage with that. Your lordship may kindly see with the medical my latest IA, that's IA file for with the there, my lord, like with the entire calculation, my IA dated 15/7/2025, 39(1) and 2, my lord. At page number 21, total medical expenses comes around, my lord, 8,83,960. This is only and only for child, for retinoblastoma, the eye cancer.
No, the direction is whatever is the amount, 60% father will bear.
Yes.
If the father is not bearing 60% of the expenditure, then you can find execution for that.
It is pending.
Yes, but execution is pending. There also he says
That the court will decide. So we don't have to go into that aspect. Court has reasonably granted 60% of the medical expenses, 60% of the educational expenses, and apart from that, 15,000 maintenance to the child. So as far as child is concerned, you are not agreed by it. You are only agreed because it is not complied with. If it is not complied with, you have a execution that you have already initiated. And as far as the
but
wife
there
is
also
concerned,
he is not paying. He says there also he points at the insurance company, his insurance policy. Your lordship may kindly see whatever we during the treatment we send messages to him to bring his insurance policy. Your lordship may kindly see at document number 6, page number 15.
what is that? 1 minute.
Your lordship may kindly see. The direction by the Honorable Family Court is very specific. On production of original to the extent of 60% of the amount for medical expenses, I have to bear. What they are doing that entire original records are produced before her insurance company and claim the maximum amount from there. And again now she is claiming that I have to pay 60% out of the entire medical expenses. Actually, what
Are you concerned with
no,
what is happening
no,
to it?
my submission before the
Minute.
please.
No, because she is paying the premium.
Yes.
For that amount, that's why she is able to get
Yes,
that
yes.
amount.
I am equally having a insurance benefit also. If he produced 60% of the original documents, medical bills, then those are not originals.
That is the original. That is the original. Your lordship may kindly, it is
If your lordship verifies it,
your lordship can see it, peruse it.
Except.
So did the court, trial court said,
Yes.
60% whatever the original bills, that should be given to you.
Please.
You will claim from your insurance company.
Or else
Did they say so?
Either I will claim from my insurance company or I will pay that one. But the direction by the Honorable Family Court is that she has to place the original medical bills. On that condition only this order has been passed. That he is not complying with.
We have complained.
That's why this Honorable Court on the earlier two occasions directed him to.
It is there, my lord, before your lordship.
In pursuant to such direction, now again he has filed one more application under order
Lordship may peruse it.
Order 39 rule 1 and 2. And
he says it is not the original.
Moreover,
it is contention
the
is that
prayer
it
is
is
that
not
I should be
original.
restrained.
Even in the trial court also says whatever we show the original, he says it is not original. He says even in that before the trial court.
No, that is
Your lordship may kindly see message also we sent on in my IA, page number 15, document number 6. As per the judge's direction, my daughter has got treatment at so and so hospital, Yelahanka, Bangalore on. So kindly also bring your insurance card for my daughter to facilitate the payment process. That also message we are sending. That also he is not bringing his insurance card or insurance policy. He is not cooperating at all, my lord, even in the trial court. Even maintenance for the child, that also due. That also he is not paying. That also I submitted before.
Skip into the other aspect. We are on this, whatever you are saying, that bills and all. So what is to be done with that?
No, my lord, that bills, entire bills, I placed before your lordship, my lord. That is the original bill. He says it is not the original bills. then what can we produce, my
How
lord?
much amount was repaid to you by the insurance company?
Insured, my lord.
Just wait, Mr. Counsel. 60,000, whatever are the original bails he will pay, 40,000 you pay and you get reimbursement from your company.
Yes, no, that's
Now
what,
you want how much amount to be paid?
now, my lord.
What is
total-
60% of the treatment?
That is 8,83,962.
83,000?
8,83,962.
Where are the bills for 8,83,960?
What, last time, the bills I have placed before your lordship. Now further bills, if your lordship order me, further bills also I'll produce
It
before.
is not like court ordering and further bills you're giving. When the court says 60% he has to bear, then for that 60%, he should have the bills.
Yes,
Entire
ma'am.
bills.
But he says it is not the original.
No, we are
He is
not.
whatever he plays, use it. He says it is not the original. Even in the court also, trial court also, his contention is that whatever I produce, it is not
The
original.
court cannot help, both of you have to help yourself. The clients have to help. Because there should be some.
My lord, your lordship may kindly see.
For a problem.
Total 8,83,000. In that 5,89,000 is the insurance from my insurance policy, and from my pocket, from my salary, I paid 2,94,421. 2,94,000. For that also he is not paying.
No, whatever is the amount, in that amount, 60% you have to pay.
Yes.
Whatever is the 60% you have to pay to her.
Please.
No, the bills, they will be given to you.
Yes. Let them furnish the bills. We will ready to.
No, don't pay to her.
Please.
No, the bills, they will be given to you.
Yes. Let them furnish the bills. We will ready to.
No, don't bother about whether she has claimed, not
No,
claimed.
we
That's
are
your
not. See,
concern.
my submission before your lordship is only specifically regarding the 60% of the
According to
original.
you, original, how it looks?
No, originals, at least it carries the seal and seal of
It
the,
is not there, please show.
Your lordship may
whatever
kindly-
they.
Please wait, Mr. Counsel. How can simultaneously both of you can argue?
Sorry, ma'am.
No, my lord, whatever the documents they have furnished to me.
You can print it out.
3rd April 2025, before your lordship. 3rd April.
Yes. Please
Third
come to
ep-
those documents.
Yes, that is all documents. 3rd April 2025 memo with original medical bills.
My document. Page number 6, document number 1.
Page number?
6, my lords. This is the document which he has furnished to me, saying that this is the original of the medical bill. Next document, your lordship may kindly see.
6 is Bangalore Airport Taxi Service.
Pagination may be wrong, that they have
What is
shown
that bill?
document.
What is that bill? What is it written on that?
Page number?
This is confirmation of successful enrollment of your below mentioned dependents of group medical coverage for the policy period from.
Please, both of you look at these documents.
Please.
And you have to name a number and you say, so you have to refer it if I have to see it. It has become a big tribe court record now. Give it to me. Please look at it. I'll call the next case. Yes. Next case.
Plaza. Cell number 20. Key to disposed 23. Key to disposed 23. For 23. For 23. Into you for petitioner.
I pay for the appellant, Palla. I just want your lordship to have page 13.
Page number 13. Yes.
Para 9.
$10,000 per month.
The petitioner, then respondent bring to, this 60,000 cannot be accepted.
What is the amount claim?
60,000, according to me, he is working in a German company.
No. How much maintenance you claimed?
Well, I have claimed 2.5 lakhs.
2.5.
That's why, my lord, the trial court holds in view of this para 6. So the court feels 10,000 is sufficient. He has no income. That's how the finding that your lordship would get it at para 12. para 13 at page 6.
It appears from the above document, respondent is not, he has contested the matter.
Not capable of it, he is duty to pay, hence liable to pay.
It's a liabilities
maintenance
are
at
filed.
10,000. Page, no, I'm impugned order. I'm talking about the impugned order, Miller.
No, I've seen that. Has he filed his statement of assets and
Yes, that is the one which he has filed. In that, Miller, that is called out in para 9, which I read to your lordship. That is called out. That is his.
No, court only says he is not capable. But what is the amount that he is earning? Which court is this?
That Miller, that's all the thing what he has said in 9 para. His Miller, your lordship, I repeat. He is employed in the said company, earning rupees 70,000 per month as his salary. Apart from salary, he does not have any other income. He is paying monthly EMI to an extent of 60,000.
Why am I not
Well,
able
that
to?
cannot be deducted. I'm giving.
Why am I not
Well,
able
that
to?
cannot be deducted. I'm
Why am I
giving.
not able to see that paragraph which you are reading, 70,000?
Para.
Impugned order.
Impugned order, Mela, para, page 13, Mela. Ink page 13, para 3.
13 is discussion. Impugned order starts at page 11.
Yes, my lords.
Is it?
Impugned order, white annexure. Which page?
Annexure, objections, huh?
Impugned order, white
Annex-
annexure, it is starting at 11.
Annexure A starts at 11, Mela, page.
Just now you are reading something. Oh, about the 12 you are reading. He's paying EMI of rupees 60,642. Cogent documents to show that the
That,
father of the withdraw.
EMI
According to
cannot
him,
be.
he's paying EMI of rupees. So according to him, what is his salary as per the
According to him, 70,000.
That is in
70,000?
70,000.
That is in the objections, but in
That is in the subjection statement.
then
Then,
assets and liabilities, it is 90,000.
but according to him, he is paying 60,000 EMI.
Where are your expenditure? Expenditure. Your
As I could see, nothing is for, except she says lumbar disc problem and she's unemployed. Well, if they're there, I would have placed. He says,
You have not filed your statement of assets and
Madam, we have filed assets or liabilities. She is unemployed. She is not working and she is suffering from a lumbar disc.
No, expenditure. You must have said.
If it is there, I would have straight away given.
It is as per requisition, Neha. There's a format you have to file.
I have not. Okay. So, expenditure.
Affidavit
I'll tell whatever it is, I will.
That is annexure.
Annexure F, Mala.
92.
Page number.
Annexure F.
Page 90. Fill the Surah. Mention her expenses for 2,50,000. General monthly expenses.
Except stating in column number 7, general monthly expenses, 2.5 lakhs, yes said.
First of all,
All
that's
other
the-
things are
that is the ground to dismiss
nil
this
anta
petition.
hakidare. I read Mela.
Next affidavit is.
All that I'm saying, I've given Mela, that also I've given. Page.
Simply like
That
round
that
figure.
Mela, your lordship would get it at page 100.
His admitted income.
According to him, his assets and liabilities. Your lordship would take at page 101, Mela.
His monthly income of the
90,000.
devotees is the
He
90,000.
says monthly income 90,000. Though in objection he says 70,000. In the declaration he says monthly income is 90,000.
If he is paying 60,000 EMI
Yes.
out of 90,000, so what is left is 30,000.
Mela, 60,000 cannot be deducted. I'll give you addition, Mela.
That's what he is saying. Then what
Can
are
I-
his expenditure? He also didn't give.
This one benefits.
Nothing apart from that. This our High
Then,
Court has held, Mela.
neither the applicant nor the respondent, both of them are not concerned with what let them, we'll do one thing, we'll set aside this order and let forward. Let them,
Unfortunately, other side is not there. That's why I want your lordship to take on the admitted. I don't want to say anything in this. I will do it, my if your lordship.
let the respondent be not there, but the court while granting an order should be on the.
I will give the detailed version. I will give it, Mela. whatever it is, except baldly stated, I also looked at it. She says 2.5 lakhs, he has not given the details.
Let the
I will
wife
give it,
file
madam.
before this court, her expenditure and the fact that she is not working.
She's
not working. And the fact
She's unemployed and she's not.
that she is not
She's
working.
not working.
And what is her expenditure?
And
what is her expenditure?
What I have to give the details of the expenditure to incurred by her.
Yes.
All that she says is, I'm living with my parents, I don't have income, and I'm lumbar this. That's all she has stated as I could gather. I am aware, Mela, that details are not forthcoming in the records.
When can you file?
Memo with the documents I have filed on 18th. That is not placed before your lordship.
I have filed with memo with some documents I have filed.
All the documents about what is your.
I will file it with an not affidavit.
And it is.
Location. Please to notice that if there was any possibility of settlement, there are no settlement between the parties to that effect. But ahead, this is the husband's petition challenging the interim order passed by the trial court. By way of an interim order, lordship was pleased to reduce it to rupees 10,000
What
per.
was the order of the family?
Trial court had granted an order of rupees 1 lakh per month. By way of
Your income is?
my take-home salary at that time was 1 lakh. Now it has been increased to in July 2024. It is increased to 2 lakhs.
What is the interim order by this court?
Income order as of now it is 10,000 rupees per month. It has been reduced to 10,000.
Why it is reduced to 10,000?
Reduced to 10,000 is for this reason.
Where is the impugned order?
Because the impugned order is at
Interim order.
page number, please. Interim order, my lords.
This court has granted.
Please.
The reason is, my lord, he is the petitioner. He did not appear. He was called upon to file.
Learned counsel appearing for the petitioner submits that the wife is staying in the house which belongs to the husband along with the daughter, and the petitioner is taking care of the son. According to the petitioner, he is paying all the educational expenses, and the petitioner is always ready to take care of the expenses of 2 children. The trial court had granted maintenance of an amount of rupees 1 lakh, which is on the higher side. According to him, as of now, his take-home salary is 1,93,000 per month. Learned counsel appearing for the respondent also does not deny the fact that wife is staying in the house which belongs to the husband. When it comes to educational expenses, submits that there is no specific instructions whether the petitioner is paying the same or not. Submits the court had rightly granted so and so.
Looking at that.
Reason, my lord, I submit, my lord. He filed a petition for divorce. My lord, we filed our objections. We filed an application for interim maintenance. Then we were called upon to file the assets and liabilities. He absented. 3 times were given to him, asking him to file the assets and liabilities. He did not file. Time was given 3 times, more than 30%. He filed 2.5 lakhs. Then what he says is, on his own, he pays PF more than the required. 40 lakhs and odd, he pays more PF. He asked the department to deduct. Then he says, deduct that amount. I'm paying income tax, deduct. I'm paying PF, deduct. Then he wants to purchase the shares from the company. And for that, he earmarks money. So he says, deduct. None of those things can be deducted. At home, he gets more than 3 lakhs.
You're saying that your salary is 4.
It's on his own document.
Assuming
I'm sure
there is a
his own
salary slip
document.
which I have filed. The salary slip says it is 4,60,000 rupees per month. It is a CTC. The concept of the IT department, the IT employees are that they're given a CTC, out of which everything else is given on a lucrative basis. They deduct taxes, they deduct PF, they deduct share, all of that is given. But right up front, what is given in hand is something called as an in-hand salary or a basic salary. That is what I draw. Rest of it is something that I'm assured in the future in the event I perform well.
While granting the interim order, court has
Please.
listed all these reasons.
Please.
How much you are paying towards education of the children?
My lords, till date I have produced the memo of calculation to that effect. And that apart.
He has given an annexure.
My lords, that is at the document that is on file on 24th September 2024. That is the memo of calculation along with documents. That was filed way back in September, but as of then had paid rupees 1,95,000 towards the daughter's educational expenses. Then at page number 2, that is the son's educational expenses at to the tune of 2,10,000. Then at the maintenance paid to the petitioner's wife, that comes up of 3,98,000. This was back.
Could your lordship have the annexer, my lord? I don't want his own document. Nothing need to be seen.
No, for,
The document enclosed along with his objections.
I
Your lordship
still
may kindly have a
stand
look
on my
at it, my
same
lord.
footing that,
What is with her?
please,
So it's your case that entire, educational, medical, otherwise
Be it
day-to-day
anything.
expenses, everything you will be paying.
please. I will not stand back from it, be it even to the extent of the daughter's marriage. I will proceed.
My lord, he cannot take the court for a ride. He cannot play prod with the court.
I will file an
I am
affidavit.
demonstrating. Your lordship may have the annexure along with the objections filed.
Yes.
Lordship got it, my lord?
Where is that?
Well, that is
He has
in,
filed an annexure along with the statement of
filed on
objections.
10/10/2024 in open court. That's a salary slip, the revised salary slip which I filed.
Lordship got it, my lord?
Yes.
Your lordship must see the down column, whatever is earned. Basic salary, 2,30,784.
Yes.
Then, my lord, professional tax. What is deducted is on the right-hand column.
Yes.
What is earned is on the left-hand column.
Yes.
Total earning is 4,61,567 rupees. 4,61,567 rupees. Out of that deductions, your lordship may kindly see, provident fund 27,694. Professional tax 200. Income tax, your lordship may kindly see, what is deducted is 1,36,363, not 2 lakhs and not what my learned friend is stating. Then stock purchase plan 46,000. Then voluntary provident fund in addition. What is?
Lord, it is like this. Assuming
Our
whatever
other
I
lane,
earn-
our expense is the lane kottilla.
Lord, that is,
He has
I'll
not
put it
given.
across this way.
He has not-
Assuming
No, he wanted to, this honorable court to believe, no doubt I get 4 lakhs, 2 lakhs are deducted for income tax, provident fund is deducted.
Not going to any of this.
I want your lordship to say,
So
his
what is the
day,
wife's requirement? That is.
I'll give,
also
I
important.
just want your lordship to have a look at the judgment, then your lordship.
No, I'm
Lord,
not.
assuming even if the salary is 4,67,000, assuming it is that way, they say, go on to say that she deserves 2 lakh, trial court has ordered 1 lakh. Now, I am taking care of the whatever expenses of the children. They will come and tell, no, I have not paid later on, which again, if it is not paid, receipts are provided. If it is not so paid, I have not on instruction. If it is not so paid, I'll have it reimbursed. That is one. The second thing is, whatever that is expenses toward the children, I will bear it even for the future. Third point, if they want to come on the footing that the wife deserves to be living on the same luxury of the husband is thrown out of his own house, he is staying on rent. Own house is given to the wife to stay. Where is the parity? Where is equity in this?
I'll submit. He gets 85,000 house rent allowance. Where is the customer? He is saying 40,000. He is earning even in that amount. 40,000 he is saving. I will give it, my lord. Entire amount declare. I know, my lord, what is running in your lordship file that I have not given the. I understand, my lord.
It's the expenditure. Let's forget about the income of the husband.
The wife is present.
She's
present.
She is, my lord.
Have a word.
The child is.
He's
No.
present, doesn't matter.
Yeah.
It counts for the respondent. Yes, what about your case? Huh? Given. This earlier matter date is not given. 1 week they said. Next week, then list these 2 matters on 31st. Yes.
Interim order may kindly be extended.
The order earlier granted is extended.
Please.
Come here.
No. I don't want you to come to the court.
Yes,
but I
sir.
want you to
If you
see
if
that.
you pardon
I want
dispense,
your-
I will do it, my lord.
Your audio is clear so that the court will be able to hear.
I will do it. I will get it set right, man. I will get that set right. I will do that. Otherwise, man, coming, I don't mind. It's a pleasure. Only difficulty is, man, physically from the car stand to walk with the walker. That's the only problem.
Can appear provided
I'll set right, my lord.
Set right,
I'll
yes.
get it set right.
Yes, yes.
Number 25, Devendra Pai.
No, no, before that passover matter is there. What has happened to this?
Then number 21.
Yes, where are the numbers for that?
Now I have placed the tag wherever they have produced the Xerox copies. Originals, we accept it. In the memo, they themselves have stated that some of the originals are not.
10% because that we have given to our insurance company.
150 rupees.
Yes, yes. See, originals, what they have produced, we will accept it. We will not deny it, that one. What they,
In 8 lakh rupees, what is the value of 150 rupees? Why are you harping on that?
no, not that, my lord.
No, first tag is at
Okay,
page number 7.
Your
So
lordship may
let us-
kindly move
don't have
further,
to
move
look at-
further.
Yes,
Most of the documents are Xerox only.
let's see. Where is the next document? $381.
Yes, okay. Given to the insurance company. In page number 64, they mentioned in our copy of 64, page number. Here afterwards, all are Xerox copies. See, what they have to do is at least 60% of the originals, they have to hand it over to me and I will see that it is reimbursed to him. That they have not did it. They claimed from the insurance company.
I understood. Yes, we'll pass orders tomorrow. This is matter for orders tomorrow.
Please,
For judgment tomorrow on the top of the list. Tomorrow morning I'll pass orders.
Tomorrow,
Second list. No arguments. I'll pass orders. Because paucity of time, I am taking it tomorrow. No further arguments. Tomorrow in the second list, this should be. Yes, next.
Cell number 25, Devendra Pai.
Respondent in first matter and
Shilak.
petitioner in the second matter.
Hmm.
Lord, the first matter is
Petitioner.
filed by the,
Day before yesterday, it was listed, my lordship. And we are filing memo for retirement in this case, my lordship, because the client is not in contact with
Lord,
us.
Order is there.
Yes, my interim order, my lordship
What
has.
we'll do is, the land council with the petition submits that. They are going to file the retirement memo and the client is not responding. Hence, the interim order granted on so and so date is vacated. Petitioner, land council and the petitioner can come up with a retirement memo. This is a matter next week.
my lord, in the second matter is a fresh
25.1.
matter.
This is a matter next week.
My lord, in the second matter is a fresh
25.1.
matter when the order for the notice.
My
my lord,
lordship,
will be-
The petition is permitted to take out handsome amounts on the council appearing to the respondent and shall file a memo to that effect by 5th of August.
in the first,
By the time the amount is not paid, the stay stands vacated. Today, next continuation is that in view of the same, the stay is vacated. The petition is at, the council is at liberty to file the memo. Yes, next.
Please.
26,
my lordship may not say that client is not responding. Memo for retirement, we will file.
memo for retirement.
Obliged.
Cell number 27.
This poses matter tomorrow on the top of the list. This also the order is
Yes,
Your
ma'am.
Lordship.
top of the list
The
tomorrow.
child was interviewed and child was interviewed.
Yes, I remember that on the top of the list. Then 28.
28,
Petitioner in this case, my lord.
28.
Lord, it's a 125 proceedings, my lord. Where, my lord, the trial court is ordered for 10,000
I
rupees.
think already notices are served on the
ಆಗಿದೆ
respondent.
ಸ್ವಾಮಿ ಸರ್ವಿಸ್ ಎಲ್ಲ
Till
ಆಗಿದೆ.
it has to be passed. Final order has to be passed.
Please, my lord,
Day
my
after
lord,
tomorrow.
my lord, my only submission is by tomorrow the matter has been listed before the trial court, my lord. My lord, the trial court is not permitting me to lead the cross examination and evidence also, my lord. Now the matter has been posted for arguments, my lord. That is the problem, difficulty, my lord.
It be tomorrow you advance arguments. Day after tomorrow we'll pass orders.
Day after tomorrow it may be taken up
Day
by
after tomorrow.
grateful, my lord. On the top of the list, please, my lord.
No, everything top. Then where will the matters go?
My lord, from morning I am
Come, it will come.
grateful, please.
I am for the respondent. Your lordship interacted with the children on that date, my lord.
This court was pleased to examine the kids in the chamber. This is with respect to visitation right, which was sought by the respondent.
a boy or a girl?
My lord,
Boy
one
with the
boy,
girl.
one girl, my lord.
Elder daughter, younger son.
Oh,
this court
that's the
was
matter.
Yes,
elder daughter, younger son.
Oh,
this court
that's the
was
matter.
yes.
yes.
Where the daughter is not liking the mother. This also tomorrow on the top of the list.
May I
Day
request
after
day
tomorrow.
after tomorrow, my lord?
Day after tomorrow.
Top of the list, my lord.
Tomorrow it is top of the list. You ask for adjournment, no top of the list. Oh, pass. Call.
Correct.
Please.
Pass over matters in list 1, sale number 27, list 1 to 27,
Why it is passed over?
because that retirement memo.
Respondents case. 3rd of March 2022.
This memo of retirement filed by whom?
Petitioner.
Correct.
Now you are undertaking to file wakalat.
No. I am for the respondent, my lord.
She is responding. Morning also she submitted.
Then why are you bothered about this? Why did you ask for passover?
My lord, morning, it was asked for when we filed wakalat, my lord.
No. It's a memo of retirement is filed without any details.
No, ma'am,
That-
we have not filed any memo of retirement. We have filed wakalat on the 3rd of March 2022.
Release the matter after 2 weeks, some date you give.
2 weeks.
Yes.
Yes, ma'am. Sale number 169. Pass over 169.
This case, a week's time may be given.
Why 169 is passed over?
My lord, we had sought for the adjournment.
Huh?
We had sought for the adjournment in the first round.
169.
Any date in the next week.
This, they
169.
169 in this one.
This is matter on 28th.
28, huh?
Yes, no further adjournments will be granted. Just give the
My lord, the interim order may be extended.
interim order earlier granted is extended.
Sale number 175.
So there are so many passwords.
Petitioner notes.
Hmm.
This is the case where, my lord, the husband filed a petition under section 9, which came to be allowed after contest. Then, my lord, she filed a petition for, not, he was there in the morning. Any day.
Day after tomorrow, more matters are there. No, then take day after tomorrow. Yes.
There is an
Keep
interim
the
order
judgment, interim order earlier granted is
Please.
extended.
Yes, ma'am.
And keep those judgments with you.
I'll keep.
Obliged.
Day after tomorrow. Sale number 191.
Appearing for the petitioner, my lords.
Yes.
I apologize when the morning session were held up in another court hall. My lords, 120.
Yes. It's not working. Keep some new pens.
ಇದು 193 ಮೇಘಾಗಿದೆ. ಇದು 193 ಮೇಘಾಗಿದೆ. Sir? 150 dismissal tomorrow. Dismissal caption ಅಲ್ಲಿ ಬರುತ್ತೆ. 50 dismissal tomorrow. Dismissal caption ಅಲ್ಲಿ ಬರುತ್ತೆ. ನಾಳೆಗಿದೆ
ಮೇಡಮ್ ಈಗ ಹೋಗಿದ್ದಾರೆ ಈಗ ಹೌದು ಇದು ಮೇಘ ಒಂದು ಇವ್ರ ಜೊತೆ ತಗೊಂಡೋಗಿ ಇದನ್ನು ತಂದ್ಬಿಟ್ಟದ್ದು
ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ ಸಿಟಿಯಪ್ಪ ವೇಟ್ ಮಾಡ್ಬೇಕು ಸೈನ್ ಹಾಕ್ಬೇಕು ಕೊಡಿ ನಾಳೆಗೆ ಇಲ್ಲ